The appeal hearing today is in the matter of CA 005-2022 and CA 006-2022 before His Excellency Justice Ali Madhani, His Excellency Justice Shamlan Sawalehi, and Justice Sir Peter Gross, and is being held by way of video conference. Any orders or directions made after or during the course of this hearing would be issued by the registry in Dubai on the judge's instructions. The appellant in CA 005 and respondent in CA 006 is represented by Adelsho Goddard. Lead counsel is Tom Montague Smith, QC. The respondent in CA 005 and the appellant in CA 006 is represented by Ahmed bin Dahi, advocate and legal consultants. Lead counsel is Roger Bowden.
Thank you very much.
With your permission, my lord, I was going to open my appeal. I'm grateful.
Please.
My lord, thank you for the indication of timings. I must admit my preparation had intended to take just a very slightly longer amount of time, but I'll race through it and perhaps not take you to quite as many documents as I was going to previously. But if I'm going too fast, please do, of course, intervene, ask questions, and I'm sure you will. You will have seen, my lord, there are two aspects to my appeal. One is in relation to the penalty claim. One is in relation to vacation pay. And so the first issue is about whether or not, as a result of the change in the law in 2019, there was an effect on the penalty that would otherwise have been due under the 2005 law. And I summarise it like this. The conditions for a penalty accruing have not changed, in the sense that there are two conditions for there to be a penalty. One is that 14 days has passed since the employment was terminated, and the other is that the qualifying payments have not been repaid. What changed was then that there was the introduction in Article 19.4, of the new law, which was I've described as a mandatory waiver of penalties in the event that there is a qualifying dispute in the DIFC courts. So the question, the law changed, I should say, on the 28th of August 2019. And so on the findings of the judge, which we don't dispute at this stage, if payment had been made for the outstanding sums at that date, 28th August 2019, then the sum which would have been due in respect of penalty under the 2005 law was 2.4 or so million dirhams. And so the question was whether, when the new law was introduced, this mandatory waiver provision came into effect such that the penalty then stopped accruing, or I'll use a neutral term perhaps, stopped accumulating after that date. And that really, as it was dealt with below, came down to the interpretation, the construction of one particular provision of the new employment law, which was Article 1.3, which you've seen quite a lot about in our submissions. And in particular, the focus of the discussion in the judgment was on one particular subparagraph of that, which is Article 1.3a. So I might just show you that, if I may. It's in Bundle H, tab 9, and page 135 of that bundle. And so what happens, the way that Article 1 works, we say, if you have that, is that the employment law of 2019 wholly replaces the 2005 law, that's Article 1.1, and then except where, Article 1.2, except where otherwise provided in the law, anything done or omitted to be done pursuant to or for the purposes of the previous law is deemed to be done or omitted to be done pursuant to the purposes of this law. So there's a general replacement of the entirety of the law subject to the carve out in Article 1.3, and that's why there was this focus at trial on that. And in particular, the judge focused on Article 1.3a, which says that without limiting the generality of 1.2 and subject only to various other articles which don't apply in this case, the repeal and replacement under Article 1.1 shall not affect A, any right, remedy, debt or obligation accrued to or incurred by any person. And that was the focus of the discussion. Now, my learned friend raises in his most recent submissions on Article 1.3b, and I'll deal with those in due course. But that was not the basis of the decision below. The basis of the decision below was the learned judge looked at the question of what was meant by accrued, what had accrued, and he found in results that the effect of the introduction of the new law had no effect whatsoever on Mr. El Fadil's penalty claim. And so if we look very briefly at what, sorry.
Can I, sorry to interrupt you, can I ask a question? Was
Yes,
much attention paid to Article 1.4?
No. No. Yes, go on.
The reason I raise it, something which we've been reflecting upon, it looks as if both parties are agreed that the new law is an equivalent provision.
Yes.
That appears to be common ground. If that's right, then the final sentence of Article 1.4 is of some interest.
Yes.
When it comes to the construction or retrospectivity arguments.
Yes.
I just mention it. And I mention it so you've both got a chance to deal with it as you go through the morning.
Thank you. I think we didn't focus on Article.
I don't want to take you out of turn. So.
I appreciate that. Perhaps I'll have a think about that and see what's made of it. But I mean, I must confess we didn't focus on Article 1.4, and it may simply be that the reason for that was that really 1.3 is in effect a self-contained code as to what survives, if I can put it like that. Whereas 1.4 is dealing with the question of what constitutes an equivalent provision, and that's all. And so, yes, the fact that the law reduces or extinguishes rights in the previous law doesn't prevent it from being an equivalent provision. I suppose one might say that it could indicate that it is quite possible for the effect of the law to be exactly that, to reduce or extinguish rights, certain kinds of rights. But then the question is, how does that fit with what the preservation of what has accrued? And I'll come on to that when I'm dealing with retrospectivity, because as you know, I think my position is, and I run two arguments now, and I only ran one below, and I accept that. The one below was you stop accumulating penalty at the date of the new law. And on that basis, there's nothing that's retrospective, because you're looking forward as to the consequences of the future events. And so the rights, there's no arguable basis to say rights have been extinguished. But the way that the judge dealt with this question was to say, well, what had accumulated, what had accrued by the date of the new law was a bare right to a penalty. And so we follow the logic of that in our ground 1.1, which is to say, well, if there's a bare right to a penalty and the quantification of that is nothing that has accrued, well, then the quantification is not the part that is preserved. It is simply the bare right. And then when you get to court, that is when you quantify it. So that's the logic. But you may well have seen, and I was going to take you to the judgment, the particular paragraphs where the judge deals with this. You may well have seen those, and I'm happy to just move faster through that, but it's probably safer to look at it, I suspect. We find that in Bundle A at page 57.
Thank you.
So you'll see there, first of all, the judge recites, you'll see under the heading, Mr. Hamid's penalty claim, the judge recites the various different statutes, which I've shown you, or I was going to take some of them, but I've shown you the relevant bits. And then at paragraph 188, the judge recites my position below. My learned friend takes a point. He says, well, this is all new. All of it is new. Even the point that I run as my second ground under this, that the penalty stops accumulating, but nevertheless is preserved up to the date of the new law. He says that's new. It isn't. You can see it from this particular passage. So if you've had a chance to read 188 to 190, rather than read them all out, what I was going to do was just summarize the effect of them. The judge recites our position, which is that we said that the penalty should be treated as accruing in the same way as it accumulates, that is incrementally. So it's a bit like interest. So what had accrued as at the date of the new law was the penalty which had accumulated by then. So it's a bit like, as I say, it's a bit like interest. You would say on a loan, if the terms of the loan change on a particular date, what interest has accrued as at the date of the change, it's not the whole of the interest that may ever fall due on that loan. It's just those parts of the interest that have accumulated up to that date. And that we said, as the judge recorded, that achieves the purpose that the legislation was intended to achieve. And that purpose was to stop penalties accumulating during the course of a relevant dispute. That's one of the purposes, and I'll show you that in a moment. And then I made the point that it didn't have retrospective effect, as I say, because the accumulation depends on facts after that date. And you'll see from paragraph 189 of the judgment that Mr. El Fadil's position was actually quite different to the one that he takes today, and different to the one that the judge accepted. So Mr. El Fadil, in fact, accepted below that the right to a penalty did not accrue on a single date. Now, that was essential to his position because only what is accrued is preserved. And so if the right to a penalty as a whole did not accrue on a single date, well, then it must have accrued incrementally, as I was suggesting. In fact, what the judge did was he said in the middle of that paragraph, with respect to Mr. Hamid's counsel, I'd reformulate this submission along these lines. And so he actually went on and decided the point on a basis which wasn't really argued. And it was quite a different basis indeed. And the conclusion at paragraph 190 was that he was persuaded that the right to a penalty accrued on a single date. Now, the quantum, he said, continued to accumulate, and that's the expression that he used. So the judge accepted that there was an accumulation of penalty after the date, and so not all of the penalty had accumulated as at the reference date, but decided that that was something different from accruing, and that under the terms of the statute, it had all accrued in one go. So, as I say, we appeal on two grounds. The first, we say...
Sorry to butt in again. Might it be said that what the judge was doing was saying a right has accrued?
Yes.
And that right is an unqualified right, albeit it's accumulating over time, inevitably. Because if you'd paid on day 20, it would have stopped accumulating.
Yes.
And might it be said, I agree this far with you, it's not immediately apparent that's what Sir Richard was saying, that under the old law, what you got was an untrammeled right, unaffected by any statutory waiver. And if that was right, then the question of construing the new statute and deciding whether it is retrospective or not raises quite an interesting point.
Yes, I see that. And I think that
sometime could you address that too?
Yes, and I think I understand what your lordship's saying, and I'm not sure that is the way that it was put by the judge. I'm not sure that is the way that it's put my learned friend, but I do see what you're saying. But ultimately, what that must mean then is that contingent rights in the broader sense are therefore preserved by this. But then the consequence of that, because it's a contingent right, because it's not a right to payment that arises at this point. It's a right that in the event that payment is not made tomorrow, I get another day's worth of penalty. I'm entitled to another certain amount. So it's a bit like I'll come on to it, but I mentioned the case of Western Glyn in my writings, and that was a situation where the court was looking at, in effect, changes to the law. And the question was, did those changes to the law affect only leases that came into effect after the date, or leases which were always in effect? And the court said, well, there's no question of retrospectivity in changing the effect of leases that are already in place. Yes, that means changing rights, but that's not a retrospective.
Will take us through that.
I will. But just pausing there, if one adopts that sort of breadth of what is meant by right, then the result is that you are continuing the application of the old law to all pre-existing employment contracts, because that's the logical consequence of that position. You're basically saying, for all contracts that are currently in place, you have contingent rights under the untrammeled rights under the existing 2005 law, and so we have to run all those off before we can introduce the impact of the 2019 law. In other words, the day before the introduction of the new law, this is what my employment rights meant. They meant everything in the contract, but also everything in the law. The day after, if I'm right, they mean, yes, everything in the contract, but everything in the new law. And so if we're preserving with that breadth the meaning of the contract before the introduction of the new law, then we're not introducing the new law at all in relation to pre-existing contracts. You're just having to wait. And we know from Article 1.3 that the new law can apply to pre-existing relationships. It says so in terms. So the breadth of what is preserved could not be, we say, as broad as that. That broadly is my submission on that. But what we say is our ground 1.1, which is we say if you follow the logic of the judge, it has the opposite result to what he said it had. The result is only the unquantified right could be accrued. And so if one detaches the quantification from what is preserved, then the quantified penalty has not accrued at all until you get to the end of the process. And so unless you take that very extreme conclusion that it's simply the effect of Article 1.3 is to preserve all employment rights, full stop, in the broadest sense, that pre-existed, and therefore that you're not changing employment rights related to parties to employment contracts in the DIFC by this law. You're just waiting for the existing contracts to run off, which could take decades. Then unless you take that conclusion, then you have to analyze it in my submission by saying, well, actually, it's just an unquantified right that is accrued, and you end up quantifying it under the new law. Now, except that's not what I argued below, but we'd say that perhaps is the logical consequence. I think that what we did argue below is perhaps the more natural meaning of the word accrue. What rights had accrued, and of course,
Mr. Smith, if you allow me.
Of course.
We understand the nature of when a legislative wants to introduce a new law, okay? So the golden rule is there is no retrospective effect of the law. And that means the law need to deal with a new issues from now onwards. What you run through the presumption that the legislative authority wanted to change a previous circumstances related to old contracts. And what would, I mean, led you to think that? Why do you think the legislature will change a contract that's running for 10, 15, 20, 50 years ago? You know what I mean?
Yes, I understand. I wouldn't say that they're changing contracts, and I don't say that that is the effect of the new law. I certainly say that they're changing the legal consequences of employment contracts. That was one of the purposes that they were intending to effect when they introduced the new law. But I certainly don't accept that there is a golden rule that there should be no retrospective application of legislation. That's the first point. That there can be retrospective application of new legislation. And I think one has to be very careful when one looks at the question of retrospectivity, and understand that retrospectivity is a spectrum. So and we'll see it from the authorities, all new laws change pre-existing rights. That's the way that the change in the law works. That's what it does. So as we walk around in the legislative environment, on day one, we have rights which arise from all different types of things, from contracts, from torts, from just being people within the legal system. When the new law is introduced on day two, our rights are different in the ways that the legislator implemented. Now, when one has to then, that it is right though, that the law is generally, there is a presumption against what we call retrospectivity, and perhaps I'll come on to that. What I was going to do first, and I think that this is where I might cut my submission slightly short, what I was going to do first was deal with my learned friend's argument, which was that this is a new point altogether.
But that's very short, forgive me. I don't think that's going to take up much time. The old, speaking for myself, Justice Ali will forgive me, and Justice Shamlan, what you did run appears from the judgment, which is that it accumulates until August under the old law, and then it's judged after August, I'm putting it very loosely, under the new law. Correct. And because you would say there was a relevant dispute, and I'm not sure if there's an issue as to whether there was or not, but let's assume there was a relevant dispute, then nothing further is paid in respect of the position after August because of the statutory waiver. That's the argument you ran below.
Yes.
And if you're right about that, Mr. Hamid gets 2.4 million dirhams rather than whatever the figure was. The argument which brings it down to nil, and which you understandably don't want to resist running, is your interpretation of the logic of the judge's reasoning.
Yes.
Well, that's a short point, and you've in fact articulated it already.
Yes.
And Mr. Bowden can deal with it. It's yes. Only new in the sense that you didn't run it below, but you say that flows from the judge's reasoning.
Yes.
If you're right, you hit the jackpot. If you're wrong, we're back to the arguments below.
Yes, quite.
Is that fair?
That's very fair. That's very fair.
So we've done.
Yes, quite. And I won't labour it, and we will hear from my learned friend. And he says I shouldn't be allowed to run my new point. Well, anyway, in fact, he says I shouldn't be allowed to run either.
Anyway, you're obviously allowed to run the other one.
Well, that's what I think.
Speaking for myself.
Thank you. All right. Well, let me move on then to deal with this point that His Excellency Justice Ali raised, which is retrospectivity. And the way my learned friend deals with these in his submissions is to say that there are in effect two questions. One is, can the law be retrospective? And the other is, what is the construction of this piece of legislation? And in fact, this is just one question. It is all a question of construction. And there are various canons of interpretation, principles of construction, which we can rely on to help us. One of them is the way in which the courts deal with retrospectivity, and I'll show you that. But there are others, and we mustn't lose sight of them. And in particular, the one that I rely on is the mischief, the purpose for which this statute is intended, and the mischief which is directed to resolve. Now, on retrospectivity, clearly that can be a factor, an important factor in the construction of a piece of legislation. But I think what I was pointing out in my submissions was that there are different degrees of retrospectivity. And so at one end of the spectrum, there are rights which have already been determined. And the courts are very reluctant to interfere with those. At the other end, further along the spectrum, you have rights which flow from events which have already occurred. And so does the new legislation change the consequences of past events in that way? And then right at the other end are rights which flow from events that occur after the new legislation is introduced. Now, obviously, in that last category, you will always have a situation where in part the rights are an accumulation of factors, some of which occurred before and some of which occurred after. And those can be sometimes the trickier situations. But my position is that that latter category is not a question of retrospectivity at all. So when you are looking at a law which changes the effect of what is going to come next, that is not retrospective. The middle category, where you have a law which, if I can put it like this, reinterprets the legal consequences of past events, that may be retrospective to an extent, but that will not always be a significant factor. And I wanted to show you two authorities, if I may, which illustrate this point, and then just show you then let's take a step back and look at Benyon, which is the leading text, at least in England, on statutory construction on these issues. So the first case was a case called West and Gwynn, which you find in bundle H, tab 26. And just to introduce this case, this was a case about whether or not legislation which was introduced, I mentioned it previously, applied to all leases, including those leases which had already been entered into, or whether it only applied to new leases. And the answer that the Court of Appeal came to was that it applied to all leases. And what it was doing, and we can see this on page 5, this is the first instance decision, but it summarises what the legislature was trying to do at the bottom. But I'll summarise it to speed things up. What it did was it said that in a lease which required consent for assignment or for underleasing, in a lease which required that consent, landlords were not entitled to impose a fine as a condition of granting that consent unless there were express terms in the lease which said so. And so what the court said at first instance in this passage on the second half, page 5 of the report, which is at page 502 of the bundle, was that the purpose of the statute was to put a stop to something which was considered an injustice. What was that? It was landlords requiring penalties be paid as a condition of giving consent. And that was a policy which applied to every lease, existing leases and past and future leases. And so it was one which was therefore meant to cover all of those. And so the effect of the legislation therefore covered all of those. And the Court of Appeal agreed with this analysis. If we go forward to page 507, as I say, this is really a question of statutory construction, but retrospectivity came into it. Page 507, the report at page 10. So you'll see in the middle of the page, the court says in the first place and then in the second place, referring to the features of the statute, but then comes on to look at the policy issue in the third place, saying in the third place, the legislature appears to have regarded the exaction of a fine as the price of consent to an assignment as so unreasonable that it ought not to be deemed to have been part of the bargain, unless expressly mentioned in the lease itself. This is a question of general policy, equally applicable to all leases. And then we can move forward to the next page, where the court dealt with retrospectivity, which is page 508 of the bundle 11 of the report. In the second line, it was forcibly argued by Mr. Hughes that a statute is presumed not to have retrospective operation unless the contrary appears by express language or by necessary implication. I assent to this general proposition, but I fail to appreciate its application in the present case. Retrospective operation is an inaccurate term. Almost every statute affects rights which would have been in existence but for the statute. Section 46 of the Settled Estates Act 1877 above referred to is a good example of this. Section 3 does not annul or make void any existing contract. It only provides that in the future, unless there is found an express provision authorising it, there shall be no right to exact a fine. I doubt whether the power to refuse consent to an assignment, except upon the terms of paying a fine, can fairly be called a vested right or interest. Upon the whole, I think Section 3 is a general enactment based on grounds of public policy, and I decline to construe it in a way which rendered it inoperative for many years. So And then there is another relevant passage on page 12 over the page, where the court uses a thought experiment to illustrate this. So dealing in the middle of page 12, page 509 of the bundle, which is about a third of the way down, suppose that by a contract between A and B, there is an event to arise a debt from B to A. And suppose that an act, there is in an event to arise a debt between B and A. So it's a sort of contingent right. And suppose that an act is passed, which provides that in respect of such a contract, no debt shall arise. As an illustration, take the case of a contract to pay money upon the event of a wager, or the case of an insurance against a risk, which an act subsequently declares to be one in respect of which the assured shall not have an insurable interest. In such a case, if the event has happened before the act is passed, so that at the moment when the act comes into operation, a debt exists, an investigation whether the transaction is struck at by the act involves an investigation whether the act is retrospective. Such was the point which arose in Moon and Durden, in King and Lee. But if at the date of the passing of the act, the event has not happened, then the operation of the act in forbidding the subsequent coming into existence of a debt is not a retrospective operation, but is an interference with existing rights in that it destroys A's right in an event to become a creditor of B. As a matter of principle, an act of Parliament is not without sufficient reason taken to be retrospective. There is, so to speak, a presumption that it speaks only as to the future, but there is no like presumption that an act is not intended to interfere with existing rights. Most acts of Parliament, in fact, do interfere with existing rights. To construe this section, I have simply to read it and look at the act in which it is contained to say what is its fair meaning. So that's the first case, and that's the distinction that is drawn. And it's very much at the fore here in my second argument, because it's the point that I was debating with your lordship earlier. It's about whether or not it can truly be said to be retrospective when what is being changed is the contingent right to a debt. And here, yes, I accept that the effect of my second argument is to change the entitlement to a contingent right, because as your lordship put it, it was an untrammeled right and now it's a trammeled right. But it is not retrospective, it's not treated as being retrospective within the meaning of the authorities. In fact, there's another case which I relied on, which is the one immediately previous to this in the bundle, and I'd just show you a very short passage from that. I'll introduce it. It's called Snedden at tab 25. And this was a claim, a statutory claim in England for compensation for a miscarriage of justice within the criminal justice system. And the claim was refused, and then there was an application for judicial review. So it's an extrajudicial decision. It's an administrative decision that's being challenged. And the challenge took a long time because there were cases going through the courts. And by the time it got to determination, the definition of what was meant by a miscarriage of justice was changed. And it was arguable that the claimant fell within the old definition, but not within the new one. And so then the question was, which definition would be applied if the decision was made again? And that was addressed on page 492 of the bundle, paragraph 12. The conclusion was, this is not a case of retrospectivity in the classic sense of an alteration to established rights. The statutory change does not require the redetermination in accordance with the new definition of a right to compensation already recognised. Be that as it may, in my judgment, the language of section 175 is clear and unambiguous. If the Secretary of State does not finally determine the right to compensation until after the new provision has come into effect, that new provision governs the application. So any new determination would be governed by change in the law, even though the change in the law, in a sense, was altering the legal consequences of past events. That's not, the court said in this case, that doesn't count as true retrospectivity. I think that highlights the risks associated with the word retrospectivity. It is a spectrum. And we see that in the passage from Benyon that I was going to take you to, which we can find at tab 27. And if we go down to page 276 of the book, which is at page 537 of the bundle.
Just give me the page again.
Of the bundle, it's 537. H537.
H537. Thank you.
Thank you. And I just wanted to pick out a few aspects of this, because it's very easy to look at cases in isolation in this field and think that there are some hard and fast rules. But it's very much better, it seems to me, to take a global understanding, global view of where the cases lead to in these sorts of things, considerations. So starting under the heading definition, although it's often convenient to describe legislation as retrospective or not retrospective, retrospectivity is better viewed as a question of degree, which will vary according to the context. The degree of retrospectivity is one of the relevant factors when considering whether the general presumption against retrospectivity is rebutted. A distinction is sometimes drawn between changes to the law in relation to events which have already taken place and changes to the law which alter existing rights or obligations or other matters, but only in relation to the future. So that's, again, the distinction that I draw in relation to the second part of my ground one. It is the latter class that throws up the most difficulties, which is only to be expected, since it is less surprising that Parliament should want to change the law for the future in relation to existing rights and obligations. The question of construction is more finely balanced. And then examples of legislation changing the law as it has effect in relation to past events include legislation to legitimise things done in the purported exercise of a power before it comes into force, and legislation to reverse an unexpected decision by the courts. This kind of legislation, sorry, we can leave it there. I was going to skip down then to the second to last paragraph on this page. The mere fact that legislation is framed by reference to legal relationships or things that happened before the legislation came into force is not generally thought of itself to make the legislation retrospective, and certainly not in an objectionable way. A change in the law is not objectionable merely because it takes note that a past event has happened and bases new legal consequences upon it. I don't think we need to look at that citation, but then quite helpful over the page under the heading events occurring over a period.
Well, you probably like the last sentence of the citation. About the body of law being justified forever.
Yeah, quite.
It's a bit extreme, yeah. But
I mean, well, it is. I mean, exactly, and I don't want to be seen to be cherry picking nice passages from cases. We can all do that, and they will point in various different directions because the principle is expressed in different terms in different places. What I'm trying to do is give a fair overview. Yeah. I'm sorry?
You say it's a spectrum.
It is a spectrum, exactly, but generally speaking, what it shows is that that there's nothing retrospective at all about changing, if I can put it like this, contingent rights flowing from a particular kind of legal relationship. That is an absolutely ordinary purpose for legislation. That's what it does. And that may be as broad as changing the law on tort, because everybody is subject to it at all times, or it may be narrower as it is in here, is changing the law of employment contracts, because not everybody is an employee, but it's very broad. There's lots of people are. The passage I was going to take you to, and just to point out, because it is helpful, it is pointing, is saying, is the one over the page on 538 under the heading events occurring over a period, making the point that there can be difficulties where new enactments deal with events which occur over a period. So it says difficulties in determining whether an enactment is retrospective are particularly acute in the case of enactments that turn on events occurring over a period. If the enactment comes into force during the period, is it retrospective or not? Little guidance can be given beyond saying that it is necessary to look at the substance of the matter. And as mentioned above, it is necessary to bear in mind that the enactment is not retrospective merely because a part of the requisites for its action is drawn from time antecedent to its path. So that means that if the preconditions for the right that is being altered partly arise before and partly arise after, affecting the legal consequences of the accumulation of all those facts, some before, some after, is not considered to be retrospective. So that demonstrates, I say, that there is a range of ways in which legislation can have some form of retrospective effect, and the court's sensitivity depends on what the impact truly is. And ultimately, what it comes down to is questions of fairness. So the statute is unlikely to be interpreted in a way which produces an unfair result. That's really what all this is getting at, because there's more risk of that, there's more risk of unfairness if there is truly retrospective effect. And we saw that, for example, in the Espresso case, which was decided in this court. That was about whether or not the new limitation period in the new law came into effect such that it barred a claim which had been brought already and brought in time under the old law. And one can see that really, underlying all of these arguments about whether it's retrospective, whether it's procedural, or any of that, the answer that the Court of Appeal reached in that case was that would be wholly and ridiculously unfair, and it can't have been the legislator's intention to do it that way. So fundamentally, it comes down to fairness. And in fact, we see that if we go down 2 pages in a passage. I will take you to a quotation very briefly from Lord Mustill on page 540. And Lord Mustill says, "In my judgment, the true principle is that Parliament is presumed not to have intended to alter the law applicable to past events and transactions in a manner which is unfair to those concerned in them, unless a contrary intention appears. It's not simply a question of classifying an enactment as retrospective or not retrospective, rather it may well be a matter of degree. The greater the unfairness, the more it is to be expected that Parliament will make it clear if it is intended." And I cited in my skeleton argument a passage from a case decided by Sir Ross Cranton in the Christchurch Borough Council. I won't take you to it, I can if you like, but the way he put it was to say incantations against retrospective legislation disappear into the ether if there is no unfairness. So that's what it's all about. And so of critical importance is what the legislator is intending to achieve. And of course, it's the fairness of the change, not the fairness of the global position. And it's not for the courts, obviously, to decide for the legislator what changes do or do not need to be made, and what changes and why those changes are being made. We can see why the legislator chose to make these changes. So we saw that in Western Gwyn, where the judge at first instance says, for better or worse, the legislator has decided that this is an unfair practice and it needs to be stopped. It's not for me, the court, to say whether that's unfair or not. And so the policy was to give effect, the policy applied to all leases, not just to new leases. So in this case, we say it's important to consider why the law was changed, the reason why the 2000 law was understood to be unfair. And I'm afraid I've cited a passage from my own book in this, albeit I didn't write the passage, I edited it, so it's not entirely self-serving. It was written sometime before the case ever came to life. It's behind tab 30, and it's a way of cutting through the authorities rather than having to show you lots and lots of cases.
Thank you.
It's on page H572. And it's in the middle, under the heading Termination Payments. Article 19 of the Employment Law 2019 can be seen as a response to the widely held perception that Article 18.2 of the 2005 law, which imposed penalties on employers for a failure to pay wages or any other amount owing to an employee within 14 days of the termination of employment, was capable of imposing unjust punishment on employers. And so that's the sort of summary of the backdrop to it. Is that accurate? Well, we can see it from the consultation paper itself for this piece of legislation, which you can find at page 469 of this bundle.
No, hold on just a minute.
Of course.
The consultation paper.
The consultation paper starts at page 459. You'll see it's dated.
And what tab? Sorry, I'm just
Oh,
moving
I'm so
between.
sorry. Yeah, no, it's my fault. It is tab 24. H24.
H24 on the relevant page. Sorry, I'm being slow.
Not at all. It's my fault. 469. So you'll see there. This is the DIFC's consultation paper for the new legislation. It wasn't quite in the form that it is now, but one can see the purpose behind the changes at paragraphs 39 to 41, where the paper says one of the more contentious provisions of the current law is the imposition of a financial penalty on an employer equal to the last daily wage of an employee for each day the employer was in arrears with payment of an employee's dues at termination of employment. The mandatory nature of this penalty was criticised in court decisions, as well as in submissions made to Difcs by establishments in the DIFC, especially in instances where the imposition of such a penalty was clearly unreasonable. And consequently, Article 18.3 of the proposed law was added. And as I say, the solution was different because there was going to be a discretionary waiver. But what is important for our purposes is that the rationale for the change was the potential unfairness of the existing regime needed to change, and that rationale applies in relation to all employment contracts, rather like in West England, not just new ones, but to pre-existing ones. And it applies to all claims as well. And so it's not every day that employers get the sympathy of the judges and employers get the sympathy of the legislator. But this was a situation where it was determined, both in courts and you see from the commentary, that the effect of the existing 2005 law was capable of producing unfair results. That needed to be put an end to. So just dealing with the points that we accumulated as pointers to construction from the Benyon text that I took you to. The first point is that the effect of my first construction, zero penalty, is retrospective in a sense. So I'm saying that in the period before the law changed, facts occurred which under the old law would have given rise to compensation, but under the new law would not. So I say that we are there in Snedden territory. It's not about rights which have already been determined. We're not ripping up past judgments, but that is now the law to be applied. So there's a change to the legal consequences of past events. But as we saw from the Benyon passage, that can be just justified where unexpected court decisions lead to a consequence, a particular interpretation of the legislation. Why is that important? Why are unexpected court decisions important in Benyon? Because it means something's gone wrong with the legislation that is being fixed by the amendment. And
sorry to interrupt.
Yes.
This argument dies a death if on a daily basis there is an accrued right to a particular sum.
Correct. So my two arguments are inconsistent one with the other. I accept that. So
this is sort of jackpot territory. It depends. It depends on no monies being accrued on a daily basis.
That's correct. It depends on no liabilities, no rights being accrued. I think it's jackpot territory depending on your perspective. If you view it from the perspective of somebody who has been awarded a certain amount of money, if you view it from the perspective of the judge's decision at first instance being correct, well, yes, it's jackpot territory. But actually, all it's doing is following through the consequences of the amendment to the law and saying that is what the law intended. The law found that while there was a relevant dispute in play, the new law that the policy behind it is that there shouldn't be an accumulation of penalty. And all we're doing is saying that that's the consequence. And even then, if you get to the 2.4 million, you're talking about a debt which has been found to be somewhere in the region, and I don't have the exact figures, but it's about 800,000 dirham to 1 million dirham, producing a penalty of 2.4 million. So it's not a debt.
No.
I mean,
you could always have paid it.
Of course, but that's no answer to the point that that has been found to be an unfair consequence, or that the provisions which lead to that conclusion have been found to be unjust. So that's the only point that I wanted to make.
Sorry, can I ask you another, just one more quick? Yeah, then we've done your first argument.
Yeah.
Is there a dispute between you that there was a relevant dispute?
Well, there is. It's been raised now by my learned friend in his latest round of submissions. It wasn't raised below. So in this sense, if I am confined to my second point, which is that it accrues on a daily basis, then there was never any dispute below that there was a relevant dispute. So I say it's too late to introduce that sort of argument. And given that my first argument, my first ground, it is simply an extension of that, which looks back, in my submission, it can't be said that there's really any factual difference, because it's the same legal set of proceedings which was started. So on the facts, there were legal proceedings. They were started within the 14 days. That's why it goes down to 0. And so the only question could be whether those legal proceedings were sufficient to trigger the mandatory waiver. But that is a decision which would be consistent for both parts of my argument. So it's too late to raise the argument now, I say. My learned friend does raise it, though. I mean, it was one of the points I was going to look at when dealing with, is it a new point? Isn't it a new point? In effect, my learned friend says, what he says about this is that the way that the claim was framed by my client was that it was a claim for monies which were due to my client and which could be set off against any entitlements which were due in return. So that was the way it was put. The total amount of the claim was put at 1.376 million dirham. You can see that from the claim form, and the argument was that all of that could be set off against the claim, against the counterclaim that was brought for these entitlements. So the short point on that is that we still say that less than that is due, because if you remove the penalty itself, this is a very modest sum that is due, and it's only the non-penalty aspects that you take into account when considering whether or not there was a net balance which could lead to a penalty being some net balance being payable in respect of those entitlements.
It's going to be said, so let's see how you deal with it. The 1.376 million claimed was a sum which you knew at all times you had no rights to.
Well, that's not the way it's been found. So that's the other way it's put.
Isn't it?
Well, no, I think it was said that certain of the people, the chairman, was aware that the sums were due.
And it is pretty remarkable.
Well, I can understand the criticisms, and we've argued the case, and clearly, you know, the judge has made the findings that he's made. It's not right that he has made that he has found that this was a fraudulent claim. It's not right that he has found that. But ultimately, the question is whether or not it falls within the mandatory waiver provisions in Article 19.4. And Article 19.4 simply talks about a dispute in respect of the sums. It doesn't qualify that in any way. Now, I can perhaps one might see the argument that it can't have been intended to include reference to fraudulent claims, but there is no finding that this was a fraudulent claim. There is no cross-appeal respondent's notice that says that the judge should have made that finding. There was a cross-appeal, that the judge should have made another finding of fraud in respect of some other evidence, but he didn't give permission in relation to that. So one has to go, I would suggest, very far to say that the nature of the claim that was put forward doesn't fall within the provisions of Article 19.4. You'd at least have to say fraud, which is the way that my learned friend puts it, but there is no finding to that effect. I'm not here to argue about that because we're just dealing with the narrow dispute, which was the one that was raised below. So that really ultimately is what we say about that. And ultimately, I mean, if a claim is, the other way he puts it is to say it's an abusive process, but if a claim genuinely is an abusive process, there are procedural rules to bring it to an end faster. But the other point is that, I mean, it's not just this as by way of waiver. Generally speaking, the effect of the legislation is to reduce the penalty very significantly. It does that in a number of ways. It imposes a de minimis provision. It does it in the way that we've discussed, which is to say if there's a relevant dispute in the courts. And it also reduces it to a maximum of 6 months' wages. And the way it does that is to impose a 6-month limitation period and then say when you bring your claim, then it stops running. So there is a maximum period during which the penalty can run. And actually, when you look at the provisions of the consultation paper, that was the intention behind the way it was, how it was structured, because the passage I've just shown you on page 469 continues. Consequently, Article 18.3 was changed, B, to cap the 18.2 penalty at 6 months' wages.
But that's so not how the law came in, is it?
Well, it's the effect of what the legislation is intended to achieve through the dual provisions of one, a 6-month limitation period, and two, suspension of penalties during the period of the dispute.
Forgive me, it's my fault. Where do I find the 6-month period?
It's the limitation period in Article 10, I believe, of the employment law. It's page 137. It's behind tab 9.
Yeah.
This is a slightly tangential point because this is about how you construe the mandatory waiver. And I'm not suggesting that the 6-month period is implemented here. I'm not suggesting there is a 6-month cap because that's not how the legislation was implemented.
Well, all that says, I don't think that takes you very far. All that says is you've got to bring the claim within 6 months.
Yes.
Then if there's a relevant dispute, there's a relevant dispute and there's a waiver.
Yes. Yes. And I agree it's slightly tangential, but my point was this, that when you put that together with the intention of the legislator, as we see it from the consultation paper, the intention of those two combined provisions was to cap the penalty at 6 months' wages.
I'm speaking for myself, but I'm struggling a bit with that. You bring your claim after 5 months and 25 days.
Yes.
The employer refuses to pay for no reason, just being difficult. Yes. And the claim, there's no relevant dispute, and the thing runs on for about 2 years. You're going to get 2 years and 6 months.
Yes, there needs to be, I see that. There needs to be a dispute. So the only requirement for a mandatory waiver is in 19.4. Yep. There needs to be a dispute in respect of any amount which is due, any relevant amount which is due.
Now, I mean, I at first instance dealt with a case.
Yes, I saw
which
that.
Doesn't assist here because there wasn't, in my view, a relevant dispute.
Yes, I understand that. I understand that. I think that the point that I was making, I do accept that it is a slightly tangential point.
I think it is.
All right. I think that all I was going to say was that it might inform your construction of what is required for there to be a relevant dispute, because the purpose, as we see from, and you may not accept that it has completely achieve that purpose. But the purpose, as we saw from the consultation paper, was to cap these things at 6 months' wages. So that, if that's right, what one looks at what is required. Is there some sort of...
You're going a bit far, and I'm just flagging it. I'm sorry to keep intervening.
No, I understand.
What you get from the consultation paper is that the old law was capable of producing unfairness. The consultation paper thought about a 6 months cap. That wasn't followed through in the legislation.
Yes, well,
it's not the way I read it.
I see.
But what was followed through was a waiver for relevant disputes. Anyway, I've said too much.
You said, well, I will move on from the point, but I think if, put it this way, if the point had been raised against me below, this is the way that I would have dealt with it, which is to say 19.4 waives the penalty whenever there is a dispute regarding any amount due. There clearly was a dispute. The question then is, well, do the findings of the judge or would be, if this was a point raised in a respondent's notice, would the findings of the judge justify departing from, justify you saying it's not anymore a dispute pending regarding any amount due? So I say I can just about see how you might get there if it really was a fraudulent claim, but that is not the finding of the judge. Organisations consist of a large number of individuals. Finding that particular individual is aware that sums were due, or was aware that sums were due, is quite different from saying that the company launched that claim in a fraudulent way. That there was a head of legal who was cross-examined at length, and the judge did not find that he, who was the decision maker, had launched this claim in a way which he knew to be false. But again, this is not a point that is raised against me at the moment. I just wanted to then complete, if I may, my submissions on the second part, the second construction, if that's all right. What I say about that is it doesn't have any retrospective effect at all. What are the conditions for a penalty? 1, you need an employment contract. 2, you need a termination. 3, you need to have 14 days pass since termination. And then 4, you need for sums not to have been paid. So the first 3, yes, they will have occurred before the legislation was changed, but the trigger, what is actually triggering each daily payment, each daily obligation, is something that comes in the future after the new law is introduced. So we're in a situation which Benyon says doesn't amount to retrospectivity at all. It's about some of the requirements are antecedent events. I mean, one just has to stop and think, I mean, is there a sensible way in which you could say that the right to a penalty in respect of the days after the law was introduced had already arisen before the law was introduced? And I say that there's no sensible way in which you can formulate that. One, because the day before the law is introduced, you don't know what's going to happen. The sums might be paid, and then that sum would not be due. That was essentially the point that was made to the judge below. My learned friend characterises my case as being about procedure, and whether or not this is some sort of, I think that's a relic from another case, because there's no argument here that this is a procedural provision. There's an exception sometimes to the retrospectivity. So all of that is irrelevant. I don't put my case in that way. Ultimately, these are guides to construction.
Thank you.
The judge did have 2 discrete reasons why my interpretation at trial would be problematic. I don't know whether you've seen that. They were given in the passages I've already taken you to in the judgment. The 2 questions were the 2 problems he had, and really the central reasoning he gave for rejecting my argument below was, firstly, he said it would cause problems with limitation. when would you start your claim? You might be statute barred. And secondly, you'd face problems with pleading the claim. Neither of those, we say, are problems. You will know well, for example, you might have a continuing nuisance. That's one of the examples where you have a liability arising incrementally over a period. And the limitation period in those circumstances bars the claim for the part of the damage that occurred before the relevant limitation period. So the better analogy is probably contractual interest. If I don't claim my interest within 6 years of that discrete item of interest falling due, then I lose that. Or if there's a contract for a series of payments, if I may lose my right to claim for some of those payments, but not for the subsequent ones. So there's no limitation problem that we can see, and there's no pleading problem either. Again, interest is a good example. Say you've got a facility and there is still interest to be due. What do? You plead it all the way up to trial, and then you get statutory interest once it's merged into the judgment. And we did this very recently in a case called EMBD and Advanced Facilities. So that what the judge did was he gave judgment in principle and then set a date for when the order would be issued, and we calculated up quite a complex interest calculation for that date. So there's no arguable pleading point which could arise in those circumstances. I mean, really, we say that there are logically two arguments, unless you go for the kind of the argument that ultimately 2019 law was not intended to change existing employment rights at all. If you take that view, then the 2019 law will run off into decades before it actually starts to bite in some places. Unless you go down that route, there are really only two logical possibilities. One is the way that the judge found it, which is that there's a bare right that is accrued. But the other, and we say, frankly, the most likely solution is that you have a daily penalty arising like interest. And each day you ask the same question. On this day, are the requirements satisfied? And that depends on the facts on that day. And it avoids having to distinguish between language like accumulation and accrue, which for non-lawyers is going to be a bit of a difficult thing to understand.
That's your first point.
That's my first point. I
So
had a
we
couple
know
of other
it's
points
a
which were
holiday,
responses to my learned friend, but I'll leave those until later. Can I go on then to deal with my second ground of appeal, unless there are any questions on the penalty issue?
I've put them as we've gone along. I don't know if Justice Ali or Justice Shamlan wished to raise anything.
No, nothing from my side. Thank you.
Nothing from my side too.
Thank you very much. So the second ground concerns an award for holiday pay. And what had happened is that Mr. El Fadil had been employed by a related Saudi entity before he was employed by TIG or TIG. And his case was that his holiday entitlement had been rolled over from his previous employment. Now, quite how that was said to have happened is a bit mysterious. And what I need to do is I need to show you the contract. I won't take you endlessly through the pleadings. I've set that out in a bit of detail in my submissions, but I'll just show you what would be required for this to work. It's bundle F, and it's page 2 of bundle F. And this is the contract of employment. And if we go to page 4, we see the vacation leave provisions. And it's clause 5.5. There are two bits that are relevant. Firstly, you will receive 30 calendar days paid vacation leave per annum, which will be taken at a time acceptable to the company without disruption to the company's business. We can skip down then to the third line from the bottom of that clause. If vacation is not taken by you, you will not receive additional compensation in lieu thereof. You will forfeit any unused vacation leave, which is not used within a year after the year it is accrued. So that is what I've described as a use it or lose it provision in relation to vacation. And then the other bit that's worth noting is at page 7 of this bundle, clause 13.1, there is a no oral variation clause. So variations to the agreement need to be in writing. That is March 2013. And at trial, if I can summarize it like this, Mr. El Fadil's case was effectively that the difference, the legal distinction between TIG and the Saudi company that he used to work for should simply be ignored. So, for example, his pleaded case was that he had been employed by TIG for 19 years rather than the 6 years which he was in fact employed, 5 years. So he said that's why his vacation rolled over. But in pleadings and in opening, it was said that there was a policy within TIG to roll over holiday in that way, as a matter of custom and practice. That was how it was put. So there was never any suggestion that there was a discrete agreement just for Mr. El Fadil that there should be this holiday that should be rolled over. It was all about whether or not some entitlement arose out of a policy of transferring employment. And we said in the judgment, the judge was clear on the latter point. So the factual investigation focused on this policy point, and in particular, there was another individual whose employment had been rolled over, and Mr. El Fadil appeared to accept in cross-examination, and the references are in the skeleton, that if the holiday was rolled over, the employee received a form confirming that his holiday was being rolled over, and he confirmed in cross-examination that he had not been given one of those forms. Ultimately, let me show you this if I may, at bundle E, page 106. At the foot of the page, this is the cross-examination, and he's talking about the change in the contract and discussion about him signing a new contract with this new entity TIG, new to him. And he said, so the point is that he signed, I asked the question, you knew from this contract that you were signing a contract with a DIFC entity, did you not? Or are you telling us you did not understand that? Answer, I understand that. As I said, they told me that this is part of the procedure. Nobody told me that this was your rights of employment, that Saudi Arabia will be jeopardized. I see. So your complaint really is that you were not advised properly. Answer, yes, about the effect it would have on the employment rights in Saudi Arabia. Is that a fair summary? Correct. Yes, I can accept that. So as I'd understood the evidence as we came out of trial, he was saying, yes, the policy was that if you get your holiday rolled over, you get a form that says it, but I never received that form. And then ultimately the complaint was, well, I didn't realize that signing with this new company meant I was giving up my old entitlement. It was never asserted that there was some discrete agreement, nor has it ever been explained how that agreement could have arisen, or could have arisen in a way that was consistent with the terms of the contract, which required a written agreement. And nevertheless, the judge found that there had been an agreement, and we see that in the judgment at paragraph 182, which is at page 56. And so the judge was here essentially finding that the contract had effectively been varied, which was never contended for, and still doesn't seem to be contended for. So the first point that we make on this is that it's impermissible for a judge to, in effect, decide a case on a basis that isn't advanced by either party. That's what's actually happened here. But even if Mr. El Fadil had argued it that way, it would have been unfair, because he's never explained how and when that agreement was reached in a way which could have satisfied that writing requirement. And we would have been able to identify the correct witness to deal with it, because one of the complaints that the judge makes is that Mr. Beckley was not part of the HR setup, and so he's unlikely to have known, if you see that in paragraph 182, he's unlikely to have known of instances where what he thought was a policy against the transfer of accrued leave was departed from by TIG, and then goes on to deal with an instance where there was a departure from that. Now, And then the second part, which was never dealt with, is, well, even if there was some agreement to roll over these days, and there were 96 of them, to employment with TIG, there was no finding or even suggestion that these use it or lose it provisions were ever varied. And so by a year later, there would be nothing left of those days anyway. Now, in his written argument for today, Mr. El Fadil doesn't really try to defend the judgment. Instead, he returns to his case that there was a general policy, and you'll see that. And if what is meant by that is some sort of written variation, then there's no pleading to that effect. But anything less than a written variation to the contract would be insufficient to work. But here, that's not the finding that the judge made. He found there was a discrete agreement of some sort. So we say that the finding of the judge is not actually defended, was never asserted, and the finding should not have been made. And if the case had been put, it would have been extinguished by the terms of the employment contract, the requirement of writing and the use it or lose it provision. That's the first point. The other discrete point is there's a very small issue about 10 days of holiday. You may have seen this. It's a small point, but there was no dispute at trial that Mr. El Fadil had taken 10 days holiday. And you see it in the judgment, for example, at paragraph 117. We took the point in opening that his holiday entitlement should take account of these 10 days. And you'll see it in our opening. I'll give you the references. In fact, they're in the skeleton already, but we made the point in opening and in closing. And the judge simply overlooked those 10 days in his calculation. That was all it was. Mr. El Fadil now seems to say that they should not really count as holiday. I mean, that's not open to him. The judge didn't make that finding. And in fact, Mr. El Fadil didn't say it at trial. He called it annual leave. And you can see it in his witness statement below. This is the very last document I'll show you. G, page 33, paragraph 39. He talks about on the 22nd of April 2018, the day I came back from my annual leave. So the short point there is that there should be a deduction. Yes, a small deduction, but it's 10 days, and that's the issue there.
I think what's said now on that is you pushed him out for 10 days, so it doesn't really count as leave.
Well, we were entitled under the terms of the contract to specify when he had to take his holiday.
No, of course, but that's not what happened. The finding of the judge is you wanted him out of the way so you could complete your partial and unfair inquiry. That's putting it in blunt terms. Is actually that's fair. And on that basis, speaking entirely for myself, I'm not very impressed about the argument for a deduction.
Understood.
I speak entirely for myself.
I think I've made the point. I think you've
made the point.
Yeah, that's it. I'll leave it there.
Yeah.
My Lord, Your Excellencies, there were a few other points on the penalty issue that were raised by my learned friend. I'll pick them up in reply if I may. But unless there are further questions now, I'll leave it there.
Thank you very much indeed.
Thank you.
I asked my judicial colleagues when they would like to resume, because we now have a break between your submissions and Mr. Bowden's. Thank you very much, Mr. Montague-Smith.
Thank you.
I'm in Justice Ali's and Justice Shamlan's hands as to when we resume.
I would say 10 minutes, fine for me.
Certainly. Thank you. 10 minutes.
Thank you.
Right, I think we're ready to go. Mr. Bowden.
Sure.
Thank you, Your Lordship. My skeleton argument is set out at document B7, and that starts at page B27.
We've read it.
Thank you, sir. And I will briefly follow this if I may. And so I'll go straight to the first point. And we've already heard from your lordship that this point won't take long, and I'll get to it. I accept that there's two ways that this was put. Up till the beginning of or as it now turns out anyway, up until the enactment of the law in August 2019, it's to be dealt with under the old law, as I understand matters, and from 2000 and that date, 28 August 2019 onwards, it's to be dealt with under the 2019 law. And so therefore it's only that latter period that we're now concerned with. And it's not simply the point, sir, of there being an inconvenience of a new argument. That's not the difficulty here. And we've set it out. It's in the prudential assurance case, and we can go to it if we like, sir. H238, and I'm at paragraph 23.
What's this aimed at, Mr. Barden? Which way of putting it?
Yes, sir. The second way, and this can only relate to the claim, the zero claim, if you like, sir.
So the objection is to Mr. Montague Smith relying on what the judge found and then standing it on its head.
Yes, sir.
Okay.
Well,
right.
Well, if we go to paragraph 23, sir, of the prudential.
Yeah.
H238, sir.
Thank you.
And it's, sorry, one page down, H239, as it turns out. And our procedural law trial is intended to be the final resolution of all matters in dispute between the parties, although a party who is dissatisfied with the outcome may appeal. That appellate process in general limited to a review of the fact of the first instance decision is a starting point that the parties are expected to put before the trial judge all questions of fact and law. And then I'm on page 5 of my submissions now, sir, that this is a fundamentally new and different way of putting it. And although it was taken without objection, what we've now, in fact, sir, the point is, none of this was ever pleaded. It came up in the list of issues. I take it my learned friend joined the case in July of 2021, and the trial started at the end of August, sir. So he bought a new legal team, bought a new broom, and all of a sudden the manner in which the penalty was claimed came under much closer focus. Previously, there had been a limitation argument raised, that is all, in the reply, but from July onwards, and certainly when it came to the points, the issues, the list of issues, it was raised in a very general way. And in opening, sir, it became clear what the case was, and we dealt with it. That is fine. What I'm now complaining about, sir, is that we've got another way of looking at it, and that is that all of this should have been completely considered under the 2019 law. And if it had been, we would have dealt with the matter differently. If it had been asserted that all of this should be dealt with under the 2019 law, there might have been a preliminary argument. If it had been if the matter had been determined in favour of Tig's argument, sir, we would have looked at the case in a different way and perhaps amended. One thing that we could have said, for example, and although the English Court of Appeal and Brent and Johnson point out that it's probably not that profitable to go speculating as to what we would have said, but there's a breach of statutory duty. Clearly, the new law, sir, sets up a whole range of statutory duties which weren't there in the old law, sir. Maybe that was another way of attacking this if we had been shut down then. So there is an inherent unfairness in allowing and now saying this whole matter ought to be considered under the 2019 law, and that given retrospective effect. Now, I also make the complaint, sir, that there's no compelling reason, and also that no explanation has been given. I've gone to the exhibit affidavit, sorry, witness statement BB1, and it doesn't set out any sort of explanation at all as to why this wasn't brought, and that is to be that should have been brought forward. And finally, sir, this Court of Appeal is the only appeal step. It's inappropriate to have a single level of judicial authority determine, and I understand this would be the first time that this point has been made in the DIFC courts and adjudicated in the DIFC courts. So it's just inappropriate to have the Court of Appeal dealing with it for the first time and determining it. So I hope that I've raced through that point, sir. And we're on to the issue of retrospective effect. And with all due respect to the cases that my learned friend has brought forward, there are some more classic authorities in relation to the issue of retrospectivity. And we are, sir, at, and I'll take you there, sir, to the Office Sharifin case. And I'm sorry, sir, I'll just go to my notes. And the first part that I wish to take the court to is page H316 and down at line C on the right-hand side. It's the old format of reports. It's internal page 494 and the judgment of Sir Thomas Bingham. And in my submissions, I put it the other way around, starting at F. A retrospective law is that which takes away or impairs any vested right under existing laws, or creates a new obligation, imposes a new duty, or attaches a new disability in respect of transactions or considerations already passed. And the right here, Your Honours, is it is indeed an untrammeled right, and the right is to a penalty until the outstanding payments are made. So read as a whole, and I'll come to it in detail in a moment, but read as a whole, that is what the section says. If you do not pay after 14 days, the employee has a right to a penalty until such time as it is paid. And that's the right. So it's easy to understand, and there's some attractiveness, and I was attracted to it in the court below. In my own submissions, I accept that there is an accrual every day, but what accrues every day is the penalty, but the right starts on the first day, and that's always our case, and it must be that way. That's logic, that's common sense, and that is what all of the authorities on this have said up until the new law came into place. So the next point that I'd wish to make, and I'm at paragraph 27 of my submissions on page B34, but it's the point there in orange at H316 down the right-hand side C. The leading English textbooks are agreed that the rule has a place in English law. And if I go down to the way it was described.
Sorry, what's in orange? I don't have orange.
Well, sorry, sir, I'm just on page H1316, internal page 494, down at line down at C and now D, sir, in the judgment. And if you can't see the paint marks I put on it, well, that's more for the better, probably, sir.
They've gone.
Great.
They don't exist.
Excellent. I do hesitate. I do say it was only there, Justice Madhani, to draw attention to the bits I wish to relate, and which were already in my submissions. But upon the presumption that the legislature does not intend what is unjust, rests the leaning against giving certain statutes a retrospective operation. They are construed as operating only in cases or on facts which come into existence after the statutes were passed, unless a retrospective effect is clearly intended. It is a fundamental rule of English law that no statute will be construed to have a retrospective operation unless such a construction appears very clearly in terms of the Act or arises by necessary and distinct implication. And I say, sirs, that is, if you like, the locus classicus on the operation of these retrospective statutes. And in relation to the Western Wind case that my learned friend has placed reliance on, well, it is a rather old authority. I see in the preamble to the office Sheriffrienne, it was cited in argument, but it wasn't cited in the decision. So clearly the judges were aware of it. But all that happened in that case, once again, it affected matters which came into existence after the statute was passed. So yes, there was an unfair procedure. Basically, I think we call it key money in some jurisdictions. That key money was very unfair, and that assignments of leases were being held up because landlords were demanding excessive key money. Well, from the date of the legislation, that was outlawed, and I think there was a very important codicil, unless the leases provided for it. So there was no right which was being taken away. Where the leases actually contained that right, the statute preserved them. Where the leases didn't have that right, the statute did not preserve them. And from the day of the enactment, no key money was to be sought, but it did nothing about key money which had been sought prior to the date of the enactment. So I think it's very easy to see why that case was not considered to be retrospective, and it's not on any analysis, but that is not what happened here. So moving right along, I'm at now page B35 of my submissions, and just going down to the In re Athelumini of 1898. Perhaps no rule of construction is more firmly established than that a retrospective operation is not to be given to a statute so as to impair an existing right or obligation, other than as a matter of procedure. And I'll come back to it in a moment, but I did understand in relation to the Christchurch case that it was, I have read it, and what it does actually say is that the enactment in that case was procedural. So that was in fact the basis for my saying that the exception that my learned friend was trying to squeeze himself into was procedural. If that's not in fact the case, well, I apologise, but that was the basis for it, because that is what the Christchurch case says. But moving on, again, so if we're not talking about procedural matters here, it must be substantive, and in which case the rule against retrospectivity is almost universal and ought to be considered to be very strong indeed. And indeed, sir, there's a rule in Benyon, and if I just take you there to my learned friends, he was relying upon Benyon, and what that says, if we can go, sirs, to H542, and I'm halfway down the page where it talks about express retrospectivity. So for a law to be truly retrospective and for the matter to be beyond doubt, it would have to be said that for example, the UK Borders Act provides that the section shall be treated as always having had effect. That is a statutory wording which would be required to give rise to the effect which my learned friend contends for. And it would have been extremely easy for the ruler to have inserted such a clause, but he didn't. Instead, he inserted wording which actually seeks, and we'll come to it, seeks to preserve not only the right, but particularly under 3A brackets 2, where litigation is contemplated, or in this case has started, and that it must continue according to its tenor. So again, just moving on, I think we can skip the procedural versus substantive parts, and if I come down to I'm at page B37, paragraph 36 of my submission. TIG's contention that says that the calculation is to take place under Article 19 of the 2019 law, which waives any penalty where there's a dispute before the court. The effect is said to reduce it to zero. If I come down to paragraph 43 of my submission, it says this. TIG's argument that the substantive right remains, but that there has been a procedural change which reduces the value of that right to zero, does not work. There's powerful authority to that effect in U Bon Tu v Kendeban, the Malaysian case, which came before the Privy Council. And then their lordships consider, and I'm at H358 here, sirs, their lordships consider that the proper approach to the construction is not to decide what label to apply to it, procedural or otherwise, but to see whether the statute, if applied retrospectively to a particular type of case, would impair existing rights and obligations. The appellants assert that a Limitation Act does not impair existing rights because the cause of action remains on the basis that all that is affected is the remedy. There's logic in the distinction on the particular facts of the Udun case, because the right to sue remained for a while, totally unimpaired. But in most cases, the loss is distinct from the curtailment of the right to sue is equivalent to the loss of the cause of action. And there is a common law, a prima facie rule of construction that a statute should not be interpreted retrospectively so as to impair an existing right or obligation, unless that result is unavoidable on the language used. Now, then we move to the High Court, the Australian High Court of Dixon, which said exactly the same things, and I probably don't need to take you there. But again, and I take my learned friend's point that the construction given to 1.3a and the retrospectivity point, they are one. I decided to split them up for ease of argument, but nevertheless, it is this fact that there is a settled right. So where a settled right is to be taken away, that is retrospective, and very clear language should be used. And that is enough to say about that. And then my learned friend goes on to fairness. In my respectful submission, he tries to turn it on its head, and he's got an extremely unattractive case when it comes to claiming fairness or unfairness in respect of his part of his client. So I'm now at page B40, paragraph 48, and I'm back to the Office Sharifiyen. And if I may, I'll just go to, it's the same point, exactly the same paragraph that my learned friend quoted from Lord Mustall, and that's at H347 at F. Thus, the basis of the rule is no more than simple fairness, which ought to be the basis of every rule. Thus, the degree to which statute has retrospective effect is not constant, nor is the value of the rights which the statute affects, or the extent to which that value is diminished or extinguished by the retrospective effect of the statute. Again, the unfairness of adversely affecting the rights, and hence the degree of unlikelihood that that is what Parliament intended, will vary from case to case. Now, and then I do mention the Association of Chartered Accountants versus Owadola. And then again, Lady Justice Asplen put it this way: one hardly needs authority for the proposition that a construction which results in manifest unfairness of any kind is unlikely to be the correct one, unless there are very clear words which point in that direction. As Snowden J has pointed out, the interpretation adopted by the association leads results to results which are both absurd and harsh. That is a very clear indication that the interpretation cannot be correct. And so the contention of TIG is to extinguish a right. That is prima facie unfair, and there are no other circumstances of the case which justify such a conclusion. Now, the trial judge looked very closely, and it was a magnificent decision on the facts, and says this: indeed, in my judgment, the senior management of TIG, particularly the chairman and Mr. Jabera, egged on by TIG's lawyers, different lawyers, I hasten to add, adopted a course of action decided on shortly before 18 April 2018, which was designed to ensure that Mr. Hamid was not involved in the steps they had determined to take to assemble as formidable and one-sided case as could be put together in order to have Mr. Hamid charged with and convicted of embezzlement and his passport confiscated. And then goes on to list 8 pieces of evidence which particularly informed that view. I mean, you know, there is no other way of putting it, Your Honours, other than to say that they set out to frame this man and to claim that there is unfairness in relation to the fact that they should have to pay a penalty which they knew would be payable. It's a very difficult submission to make, and I'm very glad I'm not making it and that my learned friend is. So, moving on.
That last point, not quite sure what to make of it. You'd be making it if you were instructed for them.
Well,
it's a difficult point to make, my sir. Very difficult. It's a difficult.
If you allow me, Mr. Borden, if you allow me, my understanding, I mean, through all the precedent that we have been taken with Montague Smith or even with you, whether retrospectivity or not, I mean, the thing going to determine that is the wording of the act or the law itself. So the court would place a very heavy weight on the interpretation of the wording of that. And I know that's going to be maybe your next.
Yes, it is.
Your next. But before you jump into that, do you have an answer to the theory of spectrum that raised by Mr. Montague Smith? Because I think this is the best time, from my perspective, is the best time to deal with the point of the theory of spectrum instead of retrospectivity. If you was following what Mr. Montague Smith saying.
Sorry, and do I have any?
The theory of spectrum instead of retrospectivity.
Ah, yes. Well, across the spectrum. Well, yes, this sits at the unfairness end of the spectrum. This is a grossly unfair result because this was a man who, and I appreciate that we're looking at the individual circumstances of this case, but this was a man who they knew was innocent. He had worked there for 19.5 years. He had risen to the top of the company. He was running the company. He was putting his own money into the company in a series of short-term loans, as he had been requested to do by the chairman. He was the chairman's closest advisor. There's a great deal of evidence there that, you know, it was even said before he left that he was highly respected and that he had given many years of faithful service to the company. That was what was said in the memo sent out in March. Whilst in the meantime, what is actually being done is that the preceding CFI 024/2018 was being put together, and Mr. Jabera, who was an executive in the company, who knew that the money was not owing, and that's in paragraph 80 of the decision. He knew that the money was not owing, and he's going to court claiming that Mr. El Fadil has stolen that money. And not only that he has stolen it, but that there's likely to be that he's in a conspiracy with other members of the staff to do so. You know, all of it was manifestly untrue, and he knew it. And indeed, they went and got legal advice, and the legal advice was to the effect that if you're going to make this claim, you need to really hammer this man and make your claim as strong as possible, which gave rise to the witness statement. And I believe we've actually got that witness statement, sir, if I can just...
Well, Mr. Bowden, if I may stop you here. When I refer to this theory of spectrum raised by Mr. Smith, so it was more than a point of law and in general terms, rather than in the evidence or special circumstances of your clients yourself.
Yes.
Maybe you was not exactly following what Mr. Smith was saying about the theory of a spectrum versus retrospectivity. But you may continue your submission. Okay, you can jump into the next point if you wish.
Yes. Well, if I may, I just in relation to that, I would draw your attention to its exhibit G29, and the page number is G1. And sorry, I'm just going from memory here, but I'm waiting for the page to load. Sorry. What that says, and I'm now at page, G5, it does appear there's some dishonesty at paragraph 24. It does appear there's some dishonesty on Mr. El Fadil's part in relation to these transactions, although the extent of that dishonesty and harm caused to TIG remains unclear. Given that there's been some dishonesty in his dealings, I believe that there's a risk that Mr. El Fadil learns that we have discovered these other transactions which he has kept hidden from TIG, and that we are conducting a thorough investigation. There's a strong possibility he will leave the country to avoid the consequences of his actions. There are obviously a number of issues to be considered. First and most pressing for the group is to ensure that Mr. El Fadil does not leave the country while the outcome of the full investigation is pending. If Mr. El Fadil flees the country, TIG will be deprived of any potential civil or criminal remedies that he may have against Mr. El Fadil. So not only did they come to this court with false evidence, but they having failed there, they took it to the police prosecutor, were initially rebuffed there, but went back again with a further complaint, and eventually had Mr. El Fadil detained. He wasn't formally arrested, I don't believe, but detained, and his passport taken for 18 months, which had catastrophic consequences for him, which are only really alluded to in the judgment. So, sorry. So the point is this, is that at all times, this company was told by its lawyers that it ran the risk of a penalty. What was said, and this is at, 18, CL 28, page F13, if I can take you there.
Are you still in the fairness point, Mr. Boyden? Because I'm really
Yes,
not
I am.
following.
Yes,
Yes.
I am.
Thank
Most
you.
certainly. Yeah.
Thank you.
The point I'm on, that not only is it not only is it unfair to Mr. El Fadil to take this away, right? I'm also saying that it's certainly not unfair to TIG to enforce the penalty against them. And the reason is because they were told that they would face this penalty if they didn't pay it. And they went ahead anyway. As a judge said, it was a risk they decided to take. But particularly, they were told by their lawyers, and at page F13, and we're 1, 2, 3, 4 paragraphs down, however, as you know, the DIFC law, employment law, imposes an obligation on the employer to pay all wages at least monthly and within 7 days after the end of the pay period. If you do not do so, then you are risking being found in breach of Article 17 of the employment law, and Mr. El Fadil would most certainly bring a claim seeking payment of that amount. And then it goes down to say, additionally, 18, pursuant to Article 18, once his employment is terminated, you will have only 14 days in which to make payment to him of all outstanding dues, failing which penalties accrue on a daily basis, equivalent to the last daily wage for each day you are in arrears. Given the amount of Mr. El Fadil's monthly salary, penalties could end up being significant. Well, they knew that on the 30th of April, 2018. And as the judge said...
Mr. Bowden, sorry, just
Yes,
following Justice Al-Madani's...
Yes. I feel I'm missing a point, yes.
Well, I don't know, but we've got to construe the statute.
Yes, sir.
You can say, you'd probably be justified to say that TIG's behaviour was disgraceful.
Yes, sir.
But ultimately, we've got to work out how the statute's to be read.
Yes, sir.
And that doesn't just apply to TIG and Mr. El Fadil.
Correct.
So we have to work out a construction which accords with the purpose of the statutory amendment and the wording of the statute. So the outrage we understand, or at least I do, but where does it go?
Yes. Well, do we have a general unfairness or a specific unfairness? And I'm certainly pointing to the specific unfairness which would exist in this case.
Sorry, just translate that into a sustainable argument, and I'll follow. As a general complaint about unfairness, yes, I follow, but where does it go?
Well,
let's assume they behaved disgracefully.
Yes, yes.
We've still got to construe the statute.
I completely agree, sir. But my starting point is to say that in taking the individual circumstances of this case, any retrospective interpretation of the statute.
We're at cross purposes. We can't say the statute is to be construed in one way in this case because we don't like TIG, but to be construed in a different way in another case because the next firm involved did not behave badly. Or if maybe there's a way of doing that, but I need an argument. other than a sort of general grass?
Well, I do understand the point, Sue, and I have always understood it, and that was why I said, well, we're looking at the individual unfairness here.
Yes.
And it is a little bit of a conundrum, isn't it? But we can't escape the point here, and I'm shortly to go to the actual statute and tell you why it should be interpreted in that way in all cases. But before we go there, I think it is important to point out that in this case, because this court is determined to do justice in every case, and in this case, there is a very strong unfairness because they have behaved appallingly to Mr. El Fadil in taking it away from him. Okay, and there is no unfairness to TIG in making that order because they knew at all times. And in my learned friend's argument, Justice Sir Peter Gross, you did point out that they could have paid at any time. And there is powerful authority from Justice Cook saying exactly that. And if I and ironically, also involving TIG. And so if we go, to the TIG appeal authorities, and it is down at the case of Rami, it is H21, document H21, sorry. And that would be page H428 is the first page of it. And this is another employee of the industrial group who took a claim for penalty and was successful before His Honour Justice Cook. And if we go down to paragraphs 10 and 11, it says this. I'm probably 4 or 5 lines down in paragraph 10 on page H431. The terms of Article 18.1 are mandatory, requiring the employer to pay end of service within 14 days, as the words shall pay demonstrate. Furthermore, the terms of Article 18 provide for what is to happen if an employer fails to pay any amount owing within that period. The wording, as the courts of appeal have said on more than one occasion, is clear in its effect. Any failure gives rise to a liability to pay the daily penalty for each day during which the employer is in arrears. The statute simply provides that the employer shall pay all amounts owing to the employee within 14 days after termination, and for a penalty if there's a failure to do so for whatever reason. And then halfway down, the 1, 2, 3 lines down on the next one, paragraph 11, it says, there may be hard cases where the effect of the law seems wholly unjust or disproportionate, as examples given in the Court of Appeal show. But the policy of the law is to both punish the employer and to compensate the employee, and thus promote good practice amongst employers. It is also open to the employer to pay the sums owing in order to stop the penalty arising or bring the penalty period to an end. And if there is a dispute about what is owing, the employer is at risk should he be proved wrong at the end of the day. Excuse me. So not only was this employer specifically advised of the penalty, but they had been a party to a case during this period of this dispute, and had been told the same thing by none other than Justice Cook. And then, if that weren't enough, if we go to H22, which is page H440, leave to appeal was sought and Justice Cook roundly dismissed it. Sir Jeremy roundly dismissed it in these terms. The application seeks to re-argue a point already decided in the DIFC Court of Appeal and affirmed by it subsequently, and to argue against the factual finding as to the absence of agreement in circumstances where the applicant defendant's own witness never testified there was such an agreement. And so leave to appeal was dismissed as well. So, sorry, that does get rid of this personal unfairness point. The personal unfairness which is said to arise for Mr. El Fadil on our part, and what my learned friend says is the unfairness to TIG on the other part. Now, if we move right along, because I'm now at really the third point of opposition to ground one, and I'm expecting that this is where Justice Madhani wishes me to go. And that is, if we look at the actual subclause, or the actual subclause bracket 1.3 of the 2019 law, and perhaps you would be kind enough to go to page B44 in my submission on that point, because I set out the section there, and I do say that we have to read the whole of it. So the first point at paragraph 63, it's already been found in the Expresso Telecom case, which Justice Madhani, of course, heard at first instance and granted leave to appeal on his own motion and as part of the judgment. Article 1(3) is a species of savings provision commonly found in interpretation acts of many national common law jurisdictions. And the decision of the Court of Appeal then goes on to recite a number of different national provisions setting that out. And then we have, and I think TIG's submission unfairly goes just to Article 3 Article 1, Subarticle 3, Subclause A, and has a myopic concentration on just those words, any right, remedy, debt, or obligation, and then only the word accrued, and then squeezes that into a very narrow submission which says, well, that accrual occurs on a daily basis, and therefore it must end at 28 August 2018, and that is the end of it. Well, of course, the sum accrues, if one likes, on a daily basis. But what is the right which is accrued? And it is any right, remedy, debt, or obligation. The right which is accrued, and I think Sir Peter put it as an untrammeled right. It is the unquantified right, and it is the right to a penalty until payment is made. And that is the key words. So, so what is preserved is, without limiting the generality of Article 1(2) and subject only to Articles 1, 4, 10, none of them count here, any right, remedy, debt, or obligation accrued to or incurred by any person, or any legal proceeding commenced or to be commenced in relation in respect of any such right, remedy, debt, or obligation under the previous law, and any such legal proceeding must be instituted, continued, or enforced, including any penalty, fine, forfeiture under this law, without prejudice to any right, remedy, debt, or obligation which is accrued or incurred prior to the commencement of this law. And my point's a simple one. What accrued prior to the commencement of this law was a right to a penalty. and the right to a penalty under Article 18 of the 2005 law, as amended by the 2012 law, is a right to a penalty until payment. Now, I'll be on the next page now, which is B45. Read as a whole.
Before you go on,
Certainly, sir.
but come back to it if you prefer to.
Yes, sir.
Mr. Montague Smith, when I raised that point, said to me that if that was right, might be logical, but if it was right, it would effectively mean that it preserved all employment contracts made prior to the passing of the new law for what he described as a run-off period that could last for decades.
Well,
And he
yes.
said that that in effect proved too much, and it wasn't an appropriate construction, given the mischief at which the 2019 law was aimed. I think I've understood his answer.
Yes. Well, that's sort of an appeal to policy. The difficulty with it is this: the first thing it runs. The first point is it's in the Expresso Telecom case is limitation. So what the one thing in the one section, which Article 1, sorry, can I start again? An article which Article 1(3) is in fact subject to is Article 10, which is a limitation provision. And so the very point of Expresso Telecom was to say, no, the limitation provision is not to be read retrospectively. Article 1(3) is not a retrospective provision, it's a savings provision, and so it's prospective. But then Abdelazim and Expresso Telecom went on to determine, well, what did the provisions of Article 1(3) mean when it said that Article 1(3) was to be read subject to Article 10, which is the limitation provision. And they decided, if we go to it, what they determined there was that you have 6 months to bring your claims. So claims that have already started, of course, they're not affected by the limitation provision, but claims that are not yet started have 6 months, I think from memory, up to or from the date of the enactment or up to the date of the enactment. Anyway, it puts in there's a limitation of 6 months. So my learned friend is wrong to assert that this will go on for decades, because the limitation period in relation to old claims being brought before under the 2019 Claim Act is over. It's finished. It's spent. So I don't believe that can ever arise. Plus, if that ever were to occur, there's now a limitation. Oh, sorry, there's not, the 6 months didn't go in. Sorry, I have another point in relation to that as well. Yes. And the other point, sir, is that by definition, and this is a Western Gwyn point, those matters must have occurred prior to the 2019 law coming into effect. So it's not going to be the case, just as Western Gwyn says. So what the 2019 law does is say that from the date of enactment, penalties shall only be payable in a much narrower set of circumstances, one of which being where there's a dispute before the courts. And so anything post 2028 August 2019 where a genuine dispute arises, no matter when the contract of employment was entered into, does not will not qualify for a penalty payment under the law, because there's nothing retrospective about that. So from 29 August onwards, or 28 August actually, onwards, any disputes are covered by the new law, no matter when the contract was entered into. And there's overlaid by a limitation point. Thirdly, that's a matter for another court to deal with on another day, properly pleaded and properly argued before it. Little surprised. I don't think I saw that argument earlier. Maybe I'm wrong, but I think that's, in any event, that must be the answer to it. Now, so I'm down at paragraph 70 of my submissions now on page B45. And so this is really the conclusion to that point. And that is Article 1.3 of the 2009 law must be read as a whole. And that's my essential submission. Article 1.3 is not limited to rights, remedies, debts, or obligations accrued to a person, but also those incurred by. So it may be that they're two sides of the same coin, but TIG's submission does nothing to answer that. And Article 1.3b specifically preserves the legal proceedings. And again, that must mean something, so that any such legal proceedings must be continued, including any penalty under this law, without prejudice to any right, remedy, debt, or obligation which is accrued or incurred prior to the commencement of this law. That, on a fair reading, must mean that the penalty, and remembering, of course, going back to the wording of Article 18, it is a penalty which persists until payment. What Article 1(3) is saying is that it must be continued under this new law. So it's a classic savings provision. Can't really be read any other way. We looked at Benyon. If it was intended to be express retrospectivity, the ruler would never have said what he did at Article 1(3). Now, I have stumbled upon a slight query here, because I made reference to the proposed 2021 employment law, and I can't give an explanation for this, but I have been looking at a version of the law which I downloaded some months ago, but it's dated March 2022, and dealing with the DIFC amendment laws, and it does not include the Article 5, which is sitting in the law that my learned friend relies upon today. So I've downloaded a law, the 2019 employment law, from the DIFC authority website, which is updated to March 2022, which doesn't include paragraph 5. I went on a research hunt and found the proposed law, which does include paragraph 5. And then, much to my surprise today, when we go to the provision which has made its way into the bundle, Article 5 is there. And if I may have leave to try and find out when that got there, or what is wrong with the article that I have downloaded from the website, I'd ask to make a further submission on that.
Well, I'm not sure, speaking for myself, it's common ground that the 2021 law is not in force, if I've understood it correctly.
Yes, sir.
Well, then what's its relevance?
Well, the relevance is this, sir. I think at H9. Yes.
Well, forget H9 for a
Document
minute.
H9, page H132.
Hang on. Just staying with your skeleton, page 20.
Yes, sir.
As a simple soul, it's not in force.
Yes, sir.
If anything, paragraph 5 doesn't help you, because it suggests that the introduction is there to cure something that isn't there. So beware what you wish for. But my really simple point is, if it's not in force, it's not in force, end of matter.
Well,
very interesting, but
I apologise for interrupting. I'd understood that it is in force. I'm looking at an enactment notice dated the 28th of February 2022. The DIFC law number 2 of 2022, which is the amendment law. So I'm not sure. I mean, my learned friend says in his recent submissions it's not in force. I'm not sure that's right. I'm not sure 1.5 helps him, and no argument was based on it below. But there we are. I'll deal with it if he wants to make a point on it.
Well, I think it is something that what I'm saying, sir, is that I downloaded the employment law, which it says that it's up to March 2022, and the one I downloaded from the official website doesn't include Article 5, which led me to the conclusion that it's only in the proposed law. And then, much to my surprise, at page H136 in relation H135, sorry, there it is. So I can't explain it. I apologize, and I've only just noticed it. So it's not in the law I downloaded dated March 2022, but it is in the version that my learned friend has obtained. He could be right. I could be wrong. Probably is, in which case it would be in force. But there's unless my eyes are deceiving me, sir, and I don't believe they are, I'm looking at another official version which doesn't include 5.
Where are you looking?
Sorry, I've only noticed this today, so during the hearing, much to my surprise, and I am looking at the version that I have been using, which I downloaded to my computer from the official site, sir, and which is dated March 2022, and which purports,
where is that in our bundle?
It's not in the bundle, sir.
Well, that's why I can't find it.
That is why you can't find it. I've just noticed this now, sir. So I had been working on the basis that it wasn't in force, and entirely to my surprise, I see, and in my preparation, I confess I reverted to looking at the copy I had, which is an official version.
I think I might be able to. Can I help?
Please.
I think the answer to this is that the 2019 law that you have in the bundle is as it was enacted in 2019, in August 2019. What then subsequently happened was that there was an amendment to that law to delete Article 1.5. The amendment came into effect in February 2022. So the corrected version of the law, I think, excludes Article 1.5. I'm not sure I'm not sure. The only reason that it matters is because my learned friend makes a point on it in his latest skeleton argument. I think he suggested that it was about to be introduced. It hasn't featured in any of the argument below or indeed in any of the argument exchanged for this appeal.
It does, with respect to seem a good point for subsequent submission, if we can just sort this out.
Well. Don't assume. Well, let me just clarify with Mr. Montague-Smith. Does the new law include a paragraph 5, or the amended law include a paragraph 5, Article 1.5, conforming to Mr. Bowden's skeleton at page 20? Let's start with that. If you look at Mr. Bowden, paragraph 72.
The answer is it did, but it doesn't anymore.
So you mean
So
it's
the amendment deleted it.
Right. It was never in the old 2019 law, or was it?
It was in the original version of the 2019 law. So it was implemented and in force between the 28th of August 2019 and I believe the 22nd of February 2022. I'm taking that from the DIFC's statutory website.
So in force between 28 August 2019 and...
bear with me, I think it was the 28th of February 2022.
Okay, that adds a slightly different dimension, because that means at all times. It doesn't seem to have featured in the argument before Sir Richard Field.
Correct.
But it does mean that Article 1.5 was in the law as it stood throughout these proceedings, save for the fact that the current hearing is post February 22.
Correct.
If I might, sir, the only problem I've got with that explanation is that why then was the proposed law proposing to introduce that section if it was already there?
No, I think it was proposing to delete it, and that's what you've misunderstood, as I understand it. I apologise. We haven't focused on this point because, as I say, it just hasn't featured. But I'm looking at the DIFC's website now, and it's DIFC Laws Amendment Law. I think it's number 2 of 2022.
No, I have added that section. Apologise.
Well, this is speaking for myself, unsatisfactory, because that would suggest that 1.5 was part of the law throughout, but nobody made reference to it. It might be of interest.
If I might, sir, take you to document H29.
Can I clarify? I'm so sorry. I misunderstand. There are 3 amendment laws. One is number 4 of 2020. One is number 4 of 2021, and one is number 2 of 2022. I think what you're now being shown is law 4 of 2021, and I had misunderstood. I thought it was 2 of 2022. I cannot find an enactment notice for law 4 of 2021 on the website.
Yeah, I just found this one, number 4 of 2021.
Yes, that's correct. So that's the one where you can, if you scroll down, Your Excellency, you'll see Article 1.5 is deleted. So it was the proposal, it seems to me, in that amendment law, that's the 2021 amendment, that be deleted. What I cannot find on the website, which I assume Your Lordship, Your Excellency is working from, is any enactment notice in relation to that law. I'd understood that it was enactment notice in relation to Law 2 of 2022. So when I mentioned the date of 28th of February, that was for a subsequent enactment of an amendment, which was 2 of 2022. So I apologise for creating more confusion.
So I don't know if you can answer this. Between 28th August 2019, so I'm now very confused, and Sir Richard Field's judgment, was there an Article 1.5 in the existing law? If so, it seems remarkable nobody referred to it.
Well, I believe no, sir, but I can't be sure either, and I have the greatest respect for my learned friends, researchers. But if I take you to H569, or perhaps we should go to H566, page H566. That's the amendment law, which was annexed to the 2021 consultation paper. And this is the draft law. And then if we come down to page H569, we see it's got the 5 sections, including sub-article 5. And my point is that hardly likely that they were proposing to put in what had already been taken out. Or if it was there in the first place, why are they putting it in again?
And if I can add to the confusion, I hope not. I've just checked the authorities bundle from the trial. The authorities bundle from the trial includes a version of the 2019 employment law, which does include Article 1.5. So it was in the statute, which was referred to at trial. Now, that doesn't answer the question of precisely what was enacted when, and I haven't done the research for that, but that would suggest that it was in force. Whether it's since been repealed is, I think, that is probably what is unclear, because we have a law which puts a line through it, an amendment law which puts a line through it, but I cannot immediately see an enactment notice in relation to that amendment law.
Well, I think the question remained, or I mean, how much weight we can put on this is 1.5.
Well, my respect for submission remains that we ought to have post-judgment submissions. I'm sure the expertise of my learned friend, and his solicitor team, we will sort this out very quickly, presumably by calling up the council at DIFCA and asking them what they in fact did.
If the submission is that there ought to be further submissions after this, I would resist that. It seems to me that this point arose because my learned friend pushed into his skeleton argument. He wants to make a point on it. He ought to be able to make a point on it. And I can answer that point in my reply. If there is a question that matters as to whether or not that law is in force, was in force, and when it became in force and when it stopped being in force, I'm sure that we can answer that subsequently. But if there are submissions to be made that this affects the construction, it seems to me that ought to be done today.
Well, I'm happy with that, but we don't know whether it was there or not.
Well, just speaking for myself, if it wasn't part of the law, but was proposed to be added, that has some significance going one way. If it was part of the law, that may have significance going a different way. We need to know which it was, I suspect. But I'm very wary of opening up post-hearing submissions. That's a recipe normally for disaster.
I couldn't agree more, my lord. I should say I've just been sent the enactment notice for DIFC Law 4 of 2021, which is the amendment law which deletes it. The enactment notice is dated the 14th of September 2021. and it came into effect 5 business days afterwards, which would be the 21st of September 2021, which would have been about 3 weeks after the trial was heard, but before the judgment was issued.
Right. Well, I think, subject to my colleagues' views, we do need a note, which should be an agreed note, as to what the law was when and when it was amended. If my colleagues are content with that, then that would help me, because I can't remember when what happened.
No, I agree to this. Yeah.
And that ought to be non-controversial.
Yes.
But that leaves us, and I think Mr. Montague-Smith may be right, if that was part of the law, if I may be forgiven for probing it, if
Yes.
Article 1.5 was part of the law, why did no one refer to it ever? And what's its significance?
Well,
If conversely it wasn't part of the law, then doesn't it suggest the law didn't have Article 1.5, which may have a significance that doesn't help you?
Well, my submission below, sir, was that all of this is to be dealt with under the 2005 law, and the article and the 2019 law has got nothing to do with it. And that's correct in my submission. So it was easy for me not to refer to it.
Sorry, that won't do. If you're right on that, yes, of course.
Yeah.
But what if you're not right on that, and we have to consider the 2019 law?
Well, I don't see any difficulty. I don't see any difficulty in considering its effect now. It's a matter of law, sir.
Well, what's your submission?
The submission is, well, I was, if it was only a proposed law, sir, I was going to say subsequent legislation provides a gloss and assists in the interpretation of the earlier legislation. But I've got if it was there at the time of the new, if it was there from the date of enactment of the new law, which the enactment notice suggests may be correct, what it means is that it very much strengthens the case against retrospectivity. So for the purposes of Article, a claim in respect of any part of penalty due, which would otherwise be excluded by Article 19.4, may be brought prior to the commencement of this law. So it clarifies and strengthens greatly the argument that penalties continue to be assessed and interpreted according to the former law, and that this new law is not retrospective.
When were these proceedings brought?
The TIG was the claimant, funnily enough, and its proceeding was brought on the, I believe, 18th of April 2018 in one provision. Mr. El Fadil counterclaimed with and so 024 was brought in early April, mid-April. 029, which was the nomenclature given to this one, was brought at the end of April, and Mr. El Fadil counterclaimed, or they were subsequently joined, and he did that in May, sir. We have the claim forms up at D, sir. We have the claim form 029, which was dated, the 13th of May for 029, and
Okay.
the 23rd of May.
On the face of it, then, the proceedings were brought prior to the commencement of the 2019 law.
Absolutely.
Well, then I, speaking only for myself, think quite strongly we need to find out whether the law as it stood did or did not include Article 1.5.
Yep.
If it did, it's truly remarkable that nobody referred to it. Speaking again for myself.
No, I say, I mean, Sir Peter, I think it's a valid point. I mean, if the point did exist in the law of 2019, should have been brought to the judge and should have been discussed in the court below.
Yes, I respectfully agree.
And I agree with my colleagues as well.
Thank you. Right. Well, Mr. Bowden, we have your submission on that. We'll await. How quickly can you, Mr. Montague, sir, how quickly can you get to the bottom of whether it was enforced or not?
I think I have got to the bottom of this. I think
Okay.
it was
How quickly
enforced.
can you put it in a note?
I can put it in a note tomorrow.
Okay,
Or I can
well,
put it in a note today, but I just need to run it past Mr. Bowden.
Clearly. When you come to your submissions, would you deal with it?
I will.
Thank you. Right. After that detour,
I then move on to have a brief look at Expresso Telecom and the reasoning of the Court of Appeal in that case. Obviously, they were dealing with the limitation provisions, and we are dealing with the penalty provisions. But in my submission, that the reasoning adopted by that division or that divisional court in that case has equal application to this case. And I think I'm at B47 or paragraph 77 of my submissions. And I'm saying that the essence of my learned friend's decision is should follow the first instance in Expresso Telecom. That's how they got around that. Okay. Well, that was respectively somewhat doubted by the judge who made the decision, who made it without the basis of proper argument from counsel on the point, considered it to be an unfair result, granted leave to appeal on the spot, and the matter was subsequently cleared up by a very experienced and eminent panel of this Court of Appeal, which included, I believe, Justice Shamlan, and overturned this in very straightforward terms based upon really non-controversial judgments, including the Australian Court of Appeal judgment of Maxwell and Murphy. So exactly, I've based my arguments prior a lot on what was said, and certainly the references to Maxwell and Murphy have come from Abdelazim Telecom. That Maxwell and Murphy is itself cited in the Office Sharifian, and it's cited in the later case about the Accountants Society as well. So, this is highly straightforward and uncontroversial law. Abdelazim say that what we're looking at in Article 1(3) is simply a savings provision, which is found in many interpretation acts all across the world, including the New Zealand Interpretation Act, the UK Interpretation Act, the Indian Interpretation Act, the Australian Interpretation Act, and many others beside. So, the only difference between this case, well, in Expresso Telecom, the actual argument was stronger because Article 1(3) of the 2019 law is said to be subject to the limitation provisions in the same act. And in this case, the penalty provisions are subject to Article 1(3). It's the other way around. And then I think I've just covered, I had quoted there at paragraph 81, what the Court of Appeal in Expresso Telecom said. And so that brings the end of my submissions on the first ground of appeal, sir.
Yeah.
Moving on to the second ground of appeal. It's not really a contract point, sir. It's an evidence point. And the overwhelming evidence is that not just for this employee, but for all employees, TIG carried forward their employment, and there was their holidays, and there was good reason for that. It was said in the evidence that it was very difficult for Mr. El Fadil to take his holidays. He wasn't able to take his holidays. He was too busy running the company. And there's also, and I'll take you to the actual clauses, which actually, to the actual documents, which make this point very plain. So, although it was the case that gratuity and holiday pay were put on the same basis, we failed on gratuity on the evidence, and we succeeded on holiday pay on the evidence. And there's nothing inconsistent or wrong about that. That's the way that the evidence fell. So it is confirmed that the essential submission always was and still is that it was C's policy to transfer the employee's accrued entitlement to vacation leave from Kingdom of Saudi Arabia to the DIFC upon their transfer. And I think my learned friend raised in his written argument that there's a no oral variations clause. Well, of course, the documents here, which we're about to look at, aren't oral variations. If anything, they're written variations, or they bring up an implied term in relation to the contract, but certainly not oral. It doesn't invoke any oral variations or no oral variations clause. But nor is it, I accept it wasn't argued either as an implied term, although it appears that the judge may have considered it in that light. It was always argued that this was their custom and practice, and the existence of a obscure employment contract which says something else might be neither here nor there. Now, if we go to the documents, sir, the first one is at page F1. And this is the one that my learned friend refers to in his submissions, but it's the treatment of Mr. Pasha. So this is, if one likes, it's collateral in a certain sense, but it's also indicates what their policy in fact was, and it shows the transfer of days over from Saudi Arabia to Dubai. And I think it's the bottom line: Mr. Pasha will resign, the company will process payment of ESOA and will rehire him with the industrial group Dubai. Exactly what the evidence was for Mr. El Fadil, that he was he resigned from Al Banawi, a big Banawi industrial group. He was rehired by the industrial group, or what became the industrial group and the DIFC entity. And just as what happened here, annual vacation balance will be carried forward to enable Pasha to take vacations without interruption. And given that he had some Mr. El Fadil had some 96 days owing at the time that he came across, sir, it would be a very unfair result indeed if they were simply taken away from him. And this demonstrates the policy was not to do that. And then if we go to the next one, which is at page F9, now, this is Mr. El Fadil's application for vacation leave. And as I understand, that is on the left-hand panel as we go down, that is the signature of the chairman, Sheikh Al-Banawi, dated 28/2014. It showed that he had 96 days accrued when he left Saudi Arabia, and he was asking for and being awarded or given 3 days then. And so it shows that, I've got it here, sir, within a few months, okay, sorry, it's at 86B of my submissions, that post-dated, so the leave request signed by Mr. El Fadil and co-signed by the chairman of the company, Sheikh Al-Banawi, and dated 8 January 2014. That's the date of this one. That post-dated Mr. El Fadil's transfer to Dubai, dated March 2013. So 10 months after, we have him still with 96 days accrued, which he could not have accrued in the single year he'd been employed. So this is a clear evidence that between the parties, this was the position. His leave had been transferred from Saudi Arabia. There's no other tenable explanation. And if one wants an explanation for the policy as to why it was so difficult for these people, particularly somebody in a key position like Mr. El Fadil, with the bottom left-hand side, we have the guidelines. No more than one employee from each department is allowed to take leave at the same time. And Mr. El Fadil had, as head of finance, had a relatively small department. A transition period of 2 working days must be allowed between the end and the commencement of another employee's vacation, working at the same department. The employee personally is responsible for reporting to corporate HR on his return from leave. The employee will not be re-entered into the payroll unless HR is notified immediately upon him reporting to work. But those were the difficulties, particularly the first two, obviously, were the difficulties faced by this employee in taking his holidays. And he gave evidence to that effect. Now, C, the last one is, sorry, it is F10 and page F10. And this is there's an email there to Mr. El Fadil asking him to look into or look at the vacation leave balances, and this appears to be across the company. And if you see conveniently, if one has to blow it up, I think, but the very first row, employee number 924, last 3 digits ending 924, is Mr. El Fadil, and it shows his vacation of 164 days owing at December 2017. So again, there's really overwhelming evidence, and I apologize, I haven't counted up the number of employees set out in that document, but it's in the dozens. It wasn't just for him, it was for all of them. And that was the evidence before the judge, and His Honour referred to those documents in his submissions. And if I go over, if it's necessary, sir, and I don't think I need to take you to it, but paragraphs, it's at page G52, and paragraphs 117 to 125 of Mr. El Fadil's 7th witness statement, G52, set out exactly the situation which applied to leave there, and this is, it's entirely consistent with it. And the judge took all of these matters into account at paragraph 182 of the judgment, and made an entirely unexceptional decision to award that holiday pay. The 2 weeks from holiday pay, yeah, they don't deserve it back. Sir Richard Field is a truly magnificent judge, and that's a decision that he's entitled
So
to make.
we'll tell him when we next see him.
Oh, I've told him several times already, sir. Thank you very much. I have no further submissions.
Mr. Bowden, thank you very much. Unless my colleagues have questions, thank you.
Hello.
Nothing from me, thank you.
May I ask my colleagues, shall we go straight on to the reply from Mr. Montague-Smith, or do we want a break? I'm happy to go on if my colleagues are, or happy to break if you prefer to.
Go on, please. Go on, please.
Please.
Okay.
Thank you, my
Mr.
lord.
Montague-Smith.
Thank you. Thank you, my lord. Thank you, Your Excellencies. I'll try and be relatively brief. In terms of retrospectivity and construction, I don't think we need to go back over the ground in any detail. As I understood my own friend's submissions, he appeared at least to accept the principle that there is a range of respects in which one can say something is retrospective. And I think Your Lordship and Your Excellencies have the point that when one is looking at the question of fairness, which is the ultimate touchstone, you're not looking at the individual facts of a particular case. It's a matter of construction. And so the question is whether one or other construction would lead in a general run to unfairness. That's the issue. And my point on that was that, well, actually, there's no retrospectivity on my original position, but even my current position, you can justify it by reference to the policies. So I'll leave that there. I can perhaps clear up a little bit, some of the mystery at least, in relation to Article 1.5. The answer is that the parties did refer to Article 1.5 in their submissions below, but by the time the submissions came, there were no oral submissions at trial, and by the time the closing submissions were made, the law had changed. That was the effect of it all. So actually, my learned friend also relied on Article 1.5 to an extent in his submissions. Let me just show you this very briefly so that we can clear it up, because I can understand it's been a major distraction, and I apologise for not having the answers at my fingertips when the issue came up the first time around. If you go to bundle D, D page 100, you will find my learned friend's skeleton argument before trial. And if you look there, I'm so sorry, I've been trying to help, I've made it worse. Got the reference wrong. Sorry, it's page D167. So these are my learned friend's employment submissions post-trial. There are two D numbers on that page, and I picked the wrong one. I'm so sorry. So it's page D167. You'll see my learned friend says paragraph 60. It's really a sort of afterthought. At the end of the line, he refers to Article 1.5, offering what he described as a belt and braces protection, preserving the cause of action. And that was a submission that was made on the 23rd of September 2001. You see that on page 169. In fact, that submission was therefore made 2 days after the amendment was made to delete section 1.5. So that's when the amendment law was enacted a week before, so on the 14th, and then on the 21st it came into effect to delete reference in the law to 1.5. And then if you go down to page 217, I think I rather treated it as something that was now neither here nor there, given that it wasn't in effect. Yeah, it is page 217 and it's paragraph 199.
Just getting there. But now, just pausing there, if it was in effect over the relevant period, the fact that it was amended before closing submissions doesn't really matter, does it?
Well, isn't the question what is the effect of it as at the date of decision, and one has to look at that point backwards to understand whether or not the change is retrospective or what the change is.
Well, that
I
would
mean,
be
that's ultimately.
That would mean that if the judge got his judgment out very quickly, you get one answer, but if you took another couple of days, you'd got a different answer. It doesn't sound right to me.
Well, that then is the question of whether or not what you're doing is retrospective or not, whether or not you're actually implementing a change which alters existing rights. But I will deal with it. But that I'm just explaining for now that the mystery that it didn't it appear to have been referred to by the parties.
Okay, let me be blunt about it. If it was in force at all times after from the commencement of the proceedings until its amendment between the end of the hearing and your closing submissions, it might be said that Article 1.5 strengthened Mr. El Fadil's case by providing a carve-out from Article 19.4.
Yes.
And it would not be vulnerable to your more general argument, which I follow, that no one was probably anticipating a run-off period in decades before the 2019 amendments came into force. So it's a point which I don't want to put it too high because, bluntly, we haven't really considered it. But on the face of it, it's a rather helpful sub-article for Mr. El Fadil if it was in force at all material times.
Well, I see that. I mean, I'm not sure that that's what the effect would be, though, when we look at it. I mean, I will look at it. Let's look at it. H135. Why don't we go straight to it rather than worry about what was said and what wasn't said?
Yeah.
What I was going to do was just take it in stages because there are various new arguments that are raised. So one of them is this 1.5. One of them is 1.4, which was actually a point, my lord, that you made in submissions. And one of them is going backwards, I'm afraid, 1.3b, and one of them is the words incurred. So there's a range of new arguments on that. So if I take them in the reverse order, perhaps we can do it that way.
Where am I going at the moment?
Page H135.
Okay.
So what the first thing that my learned friend says is that one has to look at paragraph 1.3b, and that makes all the difference. Now, to be clear, I mentioned that was not the basis for the judge's reasoning below. That's why the appeal wasn't directed at that, but it is raised in response, not by way of the respondent's notice, but we'll deal with it. So what I think the argument is that the introduction of this law shall not affect, and then B, any legal proceeding commenced or to be commenced in respect of any such right, remedy, debt, or obligation under the previous law, and any such legal proceeding must be instituted, continued, or enforced, including any penalty, fine, or forfeiture under this law, without prejudice to any right, remedy, debt, or obligation which has accrued or incurred prior to the commencement of this law. So what I say about this is that A and B make a clear distinction between, on the one hand, A, rights, remedies, debts and obligations which are accrued and incurred, and then on the other hand, the legal proceedings which have been commenced or are to be commenced in respect of any such right, remedy, debt or obligation. So the proceedings, the second part of that is dealing with the validity of the legal proceedings. So it would potentially be able to meet things like points about limitation. It is not dealing with the rights which are to be vindicated through those processes, because those are already dealt with under A. And actually you can see that because actually it's talking about at B, any legal proceeding in respect of any such right being a reference back to A, being any right accrued. So it doesn't take the argument any further than the question of what has been accrued, because you don't actually get into B anyway unless you are bringing a claim in respect of an accrued right. And then again, when one looks at the rest of the sentence, it says where there is no equivalent, any such legal proceeding shall be without prejudice to any right, remedy, debt or obligation which has accrued or incurred prior to the commencement of this law. So you still have to identify what has accrued, what has been incurred. So in my submission, B doesn't really take the issue any further at all. The next argument was that Article 13A, when it refers to obligations incurred or debts incurred, that somehow makes a difference. What we say about that is that the liabilities or the obligations which are incurred, that's just the corollary of the rights which are accrued. There wouldn't be a mismatch between the two in the legislation, because otherwise it becomes all extremely unclear as to precisely, well, logically as well. It's very difficult to see how, for example, a debt could be incurred when there wasn't a right which accrued. And so they're clearly, it seems to me, talking about the same thing. And actually, if anything, it rather helps me, at least in relation to the second way I put my penalty claim, because one just as a matter of language, one can ask the question, all right, on the 28th of August 2019, what was TIG liable for at that date? And that is what is preserved. And if you ask that question, it seems to me, I'd suggest that the answer is pretty clear. It can't have been the whole. We can't have been liable for the whole 7.5 million dirham. It was the 2.5 or 2.4 that was preserved. And then we get to Article 1.4, which your Lordship asked me about in argument. And does this affect things? The answer is it might, I suppose, because it gives us some insight into what is meant by the rest of this. Article 1.4 says, where there is no equivalent provision in this law to a provision in the previous law, the relevant provision in the previous law is deemed to survive the repeal and replacement until such time as necessary for the purposes of any legal proceeding specified in 1.3b. So what that infers, at least, is that where there is an equivalent provision, and everybody accepts that there is, then the relevant provision in the previous law does not survive the repeal and replacement. And what purpose does it not survive for? We see that from the subclause at the end of the sentence, which requires that where there is no equivalent provision, it survives until such time as necessary for the purposes of any legal proceedings specified in 1.3b. So where there is an equivalent provision for the purposes of the legal proceedings, then the existing legislation does not survive. And so we would say, well, that's quite a strong indication that what we are not doing here is is preserving the effect of the 2005 law. That actually supports me on probably both parts of it, but quite clearly on the second way that I put my penalty case. And so when we ask ourselves, what is the right that is being preserved by 1.3a, one has to make that consistent with 1.4, and the right that is being preserved cannot be a bare right that arises under the employment law, because that runs up against 1.4.
Well, you might, I don't want to put words into your mouth, but the final sentence of 1.4 rather supports your contention that the legislature contemplated the reduction or extinction of certain rights, extinguishing of certain rights.
Correct.
And that's express language.
Yeah.
Which supports at least your second argument, you might say.
Yes.
That goes far enough to show what the legislative intent was.
Yes, correct. And I think that the way I'd put it is that the difficulty that arises here is that the word right appears possibly with slightly different meanings in 1.3a and 1.4 on that interpretation.
Yes, I can see that.
What? Yeah. And otherwise, they must be inconsistent, and so one has to understand. In my submission, the way the judge interpreted it was to understand right as meaning the rights conferred by the 2005 law, in general. So the untrammeled rights that your lordship referred to. But Article 1.4, as we see, shows that it cannot mean that, because the intention must be to reduce or extinguish those rights, and therefore not apply the law in that way, not apply the old law and not continue to do so. And so what we say is that the right that is accrued under Article 1.3a must therefore be a narrower concept, and one has to read it together with the following words: right, remedy, debt, or obligation, and it must be a discrete obligation, or in this case a debt. That is a debt created by statute, and that would then lend itself to my second interpretation, which is to say what is preserved is the financial penalty that is accrued up to the date. What is not preserved is the further contingent right to continue to earn that penalty in the event that the qualifying conditions under the 2000 law apply. It seems to me that is the only way of reading those two provisions together. And then we get to Article 1.5. So for the purposes of Article 1.3, a claim in respect of any part of a penalty due pursuant to Article 19.2, which would otherwise be excluded by Article 19.4, may be brought prior to the commencement of this law. So it is only the claim in respect of the part of the penalty which is preserved. So that, if anything, pushes us further down the line, it seems to me, to my second position on the penalty, because it distinguishes between parts of the penalty, and if anything is saved, it's only that part which was due, which would be excluded by Article 19.4, but which was due under Article 19.2, and it can only be that part which accrued up to that date, the date of implementation of the legislation. Why do we know that? Because it actually expressly permits the action, that part of the action, to be brought prior to the commencement of this law. So it can only therefore be referring to that part of the claim which relates to the part of the penalty which accrued up or accumulated up to the date of implementation. It can't be talking about the rest of it. And that, again, in my submission, if it is a saving provision which has to be taken into effect, it could only save that part of the penalty which accrued up to the date of change of the law. Does that deal with it, at least from my perspective? I
have to think. The only bit I've got a question on is why the part of the penalty which it saves must be the part which is prior to commencement. It might be said against you that this saves the part which is excluded, which might otherwise have been that bit which fell after August 2000 and whichever year it was.
It seems to me that the claim, the way I read it, I would suggest it to be read, is that it's what it's dealing with. It is the preservation under Article 1.3 of part of a penalty. So a claim in respect of any part of a penalty due pursuant may be brought prior to the commencement of this law. So in my submission, it could only be referring to something which could be brought prior to the commencement of the law. And once you start to recognise that the law is distinguishing between different parts of the penalty, then it is only that part which had accrued by then, which would be brought before then. So that's how I would suggest it ought to be read. I mean, in a sense,
it's almost circular.
I'm sorry?
It's almost circular.
The law.
Well,
Or
it
my
depends really on. At this point, I'm not quite sure, but this,
That's fair.
I
It's been said before.
I think no, it's not meant unkindly at all. The meaning of Article 1.5 on this approach depends on how we've read everything else thus far to decide what can properly be. If, for instance, one took the view that everything up to August was not excluded
Yes.
by Article 19.4, then the part to which 1.5 refers is that which came after August and would otherwise have been excluded. Not sure I'm putting that eloquently, but
No, I see that.
That's the difficulty I'm having.
I think that two things. I mean, one is that this was deleted, and it was deleted for a purpose. I'm not sure we have any consultation as to why it was deleted, but one of the reasons it may have been deleted is because it doesn't assist us very much. But the second point is that it seems it's not said to be a carve out. It's said to be further explanation, as far as I can see it, of what is meant by 1.3. So for the purposes of 1.3, it's for the purposes of 1.3. So it is clarifying what is preserved by 1.3, rather than saying without, you know, subparagraph 1.3 is subject to the following. So it seems to my submission that we should be trying to read them in a way which is consistent, not reading them in a way which is inconsistent, which would be necessary if it was to be a carve out. And in that context, if one takes it, I think I would accept your observation that our construction of 1.5 rather depends on 1.3, because what it's doing, if we accept that 1.3 is not carving out claims for penalties that have accrued up to the date of the law change, then 1.5 is clarifying simply that position, and making it clear that firstly you can distinguish between the parts of the penalty, in which case it clarifies the position that what has accrued is not a single indivisible thing that accrues on one date, which is the effect of the judge's decision, but it is an incremental obligation, right, debt that accrues on a daily basis. And then the other part of it is one has to step back and look at the mischief. What is the mischief here that is being addressed by the amendments that are being implemented here? And that mischief is to change the effect of these provisions of the law. And one asks the question, is the policy which requires that change, is there any material difference between those claims which are and those claims which are not commenced before the law is change is implemented? What's the material difference between whether or not a party brings their claim on the 28th of August 2019 and brings their claim on the 1st of September 2019? On the construction that your lordship was postulating, one gets a continuing penalty, which the law has decided to abolish, and the other does not, subject to the exclusion applying. So it's not a terribly clear provision. I think that the way that we had addressed it below was that because the judge was applying the law as it applied at the time of decision, and your lordship says that's a surprising decision. It is actually consistent with the way in which this court has decided not these sorts of cases, but has decided cases where there has been a change in the law previously. The one that springs to mind is one I think that Justice Ali Al-Madani sat on, which is the Karafi case, and I think it also arose in relation to the Talim case, if you recall, which was when the law as to the jurisdiction of the court changed, and the question was whether or not the relevant time for determining whether or not the statutory test was met was the date of decision or the date of the commencement of the proceedings, and it was the date of the decision. I accept that that's a different context, but in answering the question, what is the effect of the currently implemented employment law on in this sort of circumstance? My submission below was and it appeared to be accepted was that it ought to be decided on the state of the law as it applies at the date of decision. And you say that's a bit arbitrary, but I mean, to that extent, it's always arbitrary because laws have to change on a discrete date. And is it any less arbitrary than the position where you've got the other consequence, which is that the substantive rights depend on when the claim is issued, rather than when the claim is decided. It's no more or less arbitrary than that in my submission. The court applies the law. That is the law that's in force. And so query what if the effect of amendment of Article 1, say before removal of Article 1.5, the effect was that it didn't affect proceedings which had already been started, and then you remove that, then the law as applied by the judge on the day flows from Article 1.1.1.2 and so forth, which is simply that the pre-existing legislation is replaced, but subject now only to the carve-outs that remain. So anyway, so my submission, that's that there are really 2 points here. One is I wouldn't accept that the judge was bound to apply the law as it applied for a period of the claim. Yes, it was an important period. It was the period that included the trial. It was only a period. It wasn't there at the beginning and it wasn't there at the end. So in making his decision, he was bound to apply the law as it applied at the time of decision. And second, my submissions you've heard on precisely if it does apply, what it means. I'm not sure I can help any further on that unless unless there are any further questions. The other thing I wanted to, and it didn't feature in my learned offence submissions, but I perhaps was a little shorter than I should have been. Your lordship asked the question, is it accepted that there was a dispute, qualifying dispute? And I mentioned the fact that there was a set-off claim, and your lordship said, oh yes, but it may be said against you that that was a bogus claim in one way or another. And I gave you my submissions on that. I should say, I'm so sorry.
No, go on.
I was just going to say that there were other grounds of dispute. We don't have the full run of the pleadings. We don't necessarily need to go to it, but in due course, at page D35, you will see the reply that we do have, and each of the heads of claim was in dispute. So there was a discrete dispute in relation to each of the entitlements.
To be fair to you, I haven't understood Mr. Bowden to say there wasn't a relevant dispute.
I'm grateful. In which case,
he hasn't said there wasn't a relevant dispute.
I'll leave it there then. And the final bit is the holiday bit. And what I say about this is it is all a little bit difficult because my appeal is dealing with the judgment. There's no respondent's notice that's been put in, but new cases are still emerging. So, for example, it was said that the narrative, the documents that we see are, for example, written variations of the contract. That seemed to be the suggestion. And then it was said they were evidence of the policy. I've made my submissions in relation to that. I just make one observation in relation to one of the documents you were shown, which is at F11, you were shown a document which it was said indicated that there was vacation of 164 days outstanding. If you read across the line, you will see that the final balance recorded on that schedule is in fact 30 days. Now, we don't know precisely what the background is for that, but that would be consistent with the use it or lose it provisions in the contract, and consistent with my case on the actual number of days which could have been claimed. I add that for what it is worth, but ultimately it is right that the judge made a finding that there was a discrete contractual agreement between the parties. That is not something that was ever put below, and it couldn't have survived the points that I make, in particular the use it or lose it provision.
I mean, the argument developed before us is really that everyone knew what the reality was. It's almost an estoppel by convention.
Right.
That's
well,
really which
you need an agreement.
Sorry?
Normally that would flow from some sort of agreement.
Well, Mr. Bowden would say the documents show what both parties thought. That's really what he's saying, conceptually.
Right, and then you'd have to show that they acted on it, and you'd have to establish the other aspects of the estoppel. None of that was certainly alleged below, but the starting point doesn't get off the blocks because of this document doesn't say what he says it says. It says the final balance in 2018 was 30 days. So if you rely on that,
the judge clearly thought the reality was he was entitled to it.
Correct. But he got to that position, as I understand it, by reference to an agreement, and that was never an agreement that we have any particulars of, that was ever evidenced, that was ever established. I hear what your lordship says, and the reality though is that what you would have to find is that the estoppel by convention altered the contractual entitlements between the parties, and so it would still run up against the no oral variations clause, my submission, or the requirement of variations in writing. Conduct is not sufficient to meet that test. You need an agreement, and it may be that in times of yore, those sorts of obligations, those sorts of contractual terms, any variation must be in writing. They were all subject to these sorts of arguments that everybody knows what the position really is, and we all acted accordingly. But in more recent times, rather more credence has been given to, and rather more impact has been given to those sorts of clauses, at least in English law. And so you have the Supreme Court saying, well, it means what it says. If you need an agreement in writing to change the terms of this agreement, well, that's what you need. And it's not sufficient to run these sorts of points. My lord, that's all I was going to say for today. I'm afraid we've rather overrun your proposed time schedule, but here we are.
All right. Thank you very much indeed, both you and Mr. Bowden. Obviously, we'll go away and think about it. And we will see you both, just as well we set aside Thursday morning rather, for the Mr. El Fadil's appeal. We shall see you then at 9 o'clock Thursday. Thank you all very much indeed. I don't know if there are any formalities I need to go through, but otherwise my judicial colleagues and I will meet again on the other link we have.
Sure.
Thank you, my lord. Thank you,
Thank you very much, Counsel.
Thank you very much.
Thank you.